contempt. And my lord, one more thing, my lord, the pursuant to lordship direction, I have already, my lord, on 50, हाँ बोलबो, on 50,
to your lordship's
on
order.
15th of June, এক minute. On 15th of June, since this honorable court was not available, my lord, I recorded my appearance, my lord, before the learned register. This is the, my lord, letter I have given. My lord, the carriage contemptor was personally present. And my lord, the contempt application also, I don't have any copy. Well, my specific instruction is the order has been complied with, my lord. If the copy is served upon me, you'll say the first page. But I requested my learned friend also supply me a copy so that, my lord, I can file my affidavit to put it on record that the order has been complied with. My let a copy be served, and lordship kindly record an dispensation with of the personal appearance and a
file আছে?
8th of May, your lordship allowed me to file a Talabana and other thing. But 14th of May, that has been complied with. Nowadays, my lord,
Give a copy to him.
I shall. But 14th of May, that was complied with. But I don't know whether the rule has been served by the department or not. What is the report that must be apprised to your lordship? But one thing, on the last occasion, due to some incident at my family, my lord, 7th of July, I couldn't appear when your lordship was pleased to pass this order. Mr. Gaurav Das appeared on my behalf.
Yes.
There was wrong recording in paragraph 2. Mr. Gaurav Das, learned advocate, seeks accommodation on behalf of MD Sarwat Jahan, learned advocate for the alleged contempt. Now, that should be petitioner.
Okay. Inadvertent typographical error script into order dated 7 July 2026 in the third line of the second paragraph, mentioning the words alleged contemners instead of petitioner applicants. The words alleged contemner in line number 3 in paragraph number 2 shall be read as petitioner's applicant instead of alleged contemners. The other portion of the order shall remain unaltered. Mr. Sarwar Jahan, learned advocate for the applicant petitioners, submits that pursuant to order dated 8th May 2026, the
That has been done on Malod.
petitioner applicant has duly complied by filing the required numbers of copies of the contempt application as well as Talabana. Department is directed to furnish report with regard to service of rule upon the alleged contempt.
There was a provision for providing receipt earlier. Now everything is being shown in the reflected in the server. So I have come to the 14th of May. That was the
15th
Sir
of
says that the copy has not been served.
I shall supply to.
Department directed to furnish report. Mr. So and so, learned advocate appearing for the alleged contemptor, Mr. Roy Chaudhary.
Yes.
Mr. Shobnath Roy Chaudhary, learned advocate for the alleged contemptor, submits that the copy of the contempt application has not yet been served upon the alleged contemptor. Mr. Jahan undertakes to serve.
No, I am here now.
Mr. Jahan handovers a copy of the contempt application. Mr. Roy Chaudhary, learned advocate alleged contemptor, seeks accommodation to file affidavit of compliance on the returnable date. Please this matter on 10-15 দিন পরে রেখে
let the appearance, personal appearance, maybe dispense for time being.
Since the rule was there,
personal, it is informed by learned advocate for alleged contemptor that on the date fixed, that is 15th June 2026 at 2 p.m., the alleged contemptor has appeared before the learned Registrar General, High Court, Calcutta. In view of the above, the personal appearance of the alleged contemptor is dispensed with for the time being.
Grateful.
Grateful.
Fixed on
28th July.
Good.
2 p.m. ঠিক আছে, টাইম দেখে না। নেক্সট এটা না আসছে লিস্টে আসছে, জাস্ট মিনিট, লিস্টেটা আসছে টু বি মেনশনড টাইম আগেরটা। Yes.
I'm
for the petition. Which one? Which one?
Item 4, man.
Last question, your lordship directed to file,
Hmm.
directed them to file a report.
My lord,
Compliance
I'm,
report.
my lord, I'm led by Mr. Oyan Mukherjee. Sorry. Sorry, my lord, Mr. Tanmay Mukherjee is occupied in another court. Not kindly give.
File your affidavit of compliance.
But I have not.
Then why are you moving, sir? Where is your affidavit of compliance?
Sir, I have no copy.
Get the affidavit of compliance and file. Give a copy to him. Passed over.
I'm led by Mr. Amitav Ghosh.
Right.
Appearing for the alleged contempt pursuant to my lord's direction, or I am filing. If
Complied.
my lord
My lord, we have served.
What was the order?
দেখবে সাহেবকে দেবেন এটা
Affidavit of service.
Where is the order?
my lord page 6 my lord the order passed পিটিশনের নামটা রেসপন্ডেন্টের নামটা বার হ্যাঁ
Thereafter, after passing the order,
now my lord only one thing in the writ petition my lord the private respondent is the Madan Gayan. My lord the from the order my lord will find my lord the plan my lord the granted in favor of the wife of the Madan Gayan and my lord the made construction. Choitali Gayan is not the party respondent in the instant writ petition. So my lord in our order my lord we have stated that Choitali with plan my lord made construction and some deviation is there in the second paragraph I have said my lord so my lord since Choitali is not the party respondent my lord they can my lord file another writ petition my lord that then my lord we have take steps against the Choitali also.
My lord, this resolution is totally contradictory with their own statement. In terms of RTI, they stated that there is no building sanction plan. This is their reply.
My lord, no
My lord-
building sanction plan my lord in favor of the Madan. My lord that is not my lord,
of Sri Madan. Madan.
my lord I have again my lord my this is my consistent submission. My lord against Madan no sanction plan. Well, against Choitali sanction plan is there. Well, Choitali is not the party respondent in this writ petition.
Then
But whether this, I don't know whether this resolution does not corroborate any document in terms of submission of my learned friend.
मतलब pursuant to my lord direction मतलब the notice issued मतलब my lord's kindly comes to my lord's order. My lord's order was that upon notice मतलब cause a field inquiry and thereafter upon hearing pass a reasoned order. So मतलब that was followed. मतलब that was followed. They appeared and मतलब inspection मतलब they also present. Now this order has been passed.
so you forward this order to the SDO.
मतलब SDO
আমরা অলরেডি সেন্ড করে দিয়েছি
কিসে
এসডিও কে অলরেডি এসডিও কে আমরা
Yes, मतलब we have forwarded this मतलब in terms of this मतलब order. This is
The second paragraph.
since some illegal deviation is there.
Which page? Page
मतलब in this page 6 मतलब the signature is there.
Paragraph 2.
paragraph 2 is the order has been forwarded to the SDO.
Yes, yes.
Where is the forwarding letter?
ফরওয়ার্ডিং লেটার করে দিয়েছি এখানে
मतलब kindly see receive stamp is there to the SDO office.
There is a deviation that has also been reflected in paragraph 2 of the case.
Yes, yes. मतलब that I what we have find मतलब that is stated there.
So let him take steps. SDO.
My lord, may I submit one? My lord,
Affidavit of
in
compliance.
respect of this resolution, my lord,
no plan, nothing has been annexed to corroborate that
अरे
this
totally
decision
party
made
নয় তাকে
in terms of that minister that thing. Well, that has
Affidavit of
been done.
compliance filed on behalf of the alleged contemnant is taken on record. It is found that pursuant in compliance to the order of this court passed in WPA dated 13th April 2026. Now, what is the date of the order?
8/6/2026.
Writ petition order.
This petition without 16938 of
मतलब
2000.
order dated 22nd July 2025.
22nd July 2025 passed in WPA 16938 of 2024. The alleged contemner has passed order and the said order has been forwarded to the office of SDO Baripur for further course of action under section 23 of the West Bengal Panchayat Act. In view of the above, the contempt application being WPCRC 90 of 2026 stands disposed of. Rule is discharged. Personal appearance of the alleged contemner is dispensed with.
मतलब only record these things. मतलब the person against whom we shall take steps, he is not the party. So kindly clarify.
Which?
मतलब Choitali, we granted permission in favor of Choitali. There is some deviation. So
23 does not speaks of any party. Whenever there is a violation, the concerned whosoever is there, he should be notified.
मतलब
This Choitali, Madan or whosoever.
yes, ma'am.
Now, if Choitali has deviated, now
Yes,
SPO
that-
is at
that is-
liberty to issue notice to the person who has illegally made construction and remove that in accordance with law.
Ma'am.
Well, can you tell time frame?
No time frame. Let him issue the notice.
Get one.
Item 6, I'm for the petition. Your Lordship, kindly come page 30
Page?
of the contempt application. It is a contempt application for the first time. On
Page 30.
Your Lordship passed an order on 29th October 2025.
Notice issue.
Acha.
After 4 weeks. That will appear for 4 weeks to have notice.
Yes, sir. Yeah. One prayer I make, my lord, with regard to 6, my lord, liberty be given, my lord, to correct the cost title. In the cost title, I have changed in place of 29, it has been written on 24th. It should be corrected. My lord. Order dated 29th October, but in the cost title, it is written 24th. Type mistake. এটা do লিখে না।
Liberty on the prayer of learned advocate for the
Page 2.
petitioner, leave is granted to correct the cost title of the contempt application.
Order dated. Page 2, order dated.
Hmm.
In place of 29, মানে top.
To the extent of correcting the order, date of order.
Yeah.
Correct?
Correction করবে। ওখানে গিয়ে correction করবে।
Item 7, my lord, for the petitioner.
From for the state.
In that matter, my lord.
23.
Yes, 23. The last occasion, Mr. Chatterjee.
Loknath Chatterjee is not.
My lord, I'll just get them, my lord, the reports come, my lord.
Yes.
My lord, just
Pass
if it
over.
can be just pass on. Oh, the signed report ta kothay gelo?
Sit down, sit down.
I'm sorry.
First sit down, we take it afterwards. Take it up. Sit. একটু পাস ওভার রাখুন 5 মিনিট। Next.
Madam, petitioner, my lord. And remember this matter, my lord, asking for death certificate of mother.
Okay, yes, yes.
Yes, my lord.
Yes, what is the report? Mr. Singh?
My lord, report has been filed.
This compassionate appointment.
No, my lord.
Compassionate.
Pension, my lord. Family pension as a disabled person, my lord.
Okay.
I am petitioner
Son.
as a disabled person. My son.
Yes. Where is the inquiry report of the BDO?
My lord, video is not party in this writ petition, your lordship. And page number 23, your lordship, a report on the
It
basis
is
of.
not required the BDO. We are not assessing or examining the report of the BDO. An inquiry report was submitted before the additional district magistrate who issued the legal year certificate on the basis of the BDO's inquiry report. I want to see that report because the state is insisting upon filing a formal death certificate of the mother. If the inquiry report shows that the mother has died and on the basis of that the legal year certificate is issued, you can very well act on the legal year certificate of the deceased. Where is the report of the BDO Nanur?
Page 23, kindly see, my lord.
ভিডিও তো পার্টি নেই
না পার্টি তো দরকার নাই, ও তো রিপোর্ট ইনভেস্টিগেশন করে তো রিপোর্ট দিয়েছে। জজ সাহেবকে বলুন।
I know direction be given to the video, so we have. There are several videos, lordship, and we are.
No, specific Nanur video is specifically direction by
Nanur 1, 2 or 3.
কোন একটাই আছে
একটা
এখানে পেজ নম্বর পেজটা ক্লিয়ার করা আছে দেখুন না।
Who is filing this? Where is the legal year certificate?
So my lord,
page number
23, my lord.
Page number 23.
20?
23. Annexer P5. It is
You are having that?
Page number 23. Page number 23.
Page 23.
My lord. My lord.
This copy of this order has been forwarded to the District Inspector of Schools PE.
My lord.
He is a party here.
My lord.
So you file a report through the District Inspector of Schools whether the office has refused any legal year certificate issued by the Additional District Magistrate. Why?
My lord, we have already filed to the District Inspector.
So he has not disclosed that. He has not disclosed. He has stated that I have asked for a formal death certificate. Now he is not giving that. For that reason, I cannot issue the family pension. But there was an inquiry made by the Block Development Officer Nanur and Additional District Magistrate forwarded that order. A copy has been forwarded to the District Inspector of Schools.
My lord. And a specific instruction be given, my lord, so that we can ask.
my lord considered
On the prayer of the learned advocate for the petition, leave is granted to implead the Additional District Magistrate General Birbhum as added respondent number 6. Additional District Magistrate Birbhum added respondent number 6 is directed to furnish a report annexing the inquiry report of BDO Nanur block, Nanur Development Block, submitted before it VDA memo number 994/NDB/2024 dated 23rd April 2024, which was forwarded by SDO Bolpur VDA memo number 121/RM/BOL dated 21st May 2024.
By hearing now,
Please.
added this respondent.
Place this matter on next week. Next week.
2 weeks. Kindly, you lots of 2 weeks.
দেখো 2 সপ্তাহ পরে কি ডেট আছে? কবে? 28th.
Duplication.
Now 7th.
Same position, my lord.
এটা উপরের দিকে রাখবে 28th এ। দেবনাথ বাবু এই ম্যাটারটাকে উপরের দিকে রাখবে।
টাইমটা কি বললেন সেম?
না না বলে ওই টপ পজিশন যে
যাচ্ছে একটু দেবেন, যাচ্ছে একটু দেবেন।
এরপরে টু বি মেনশন টু বি। Yes.
My lord, the entire difficulty, my lord, is, my lord, what my learned friend has pointed out on the last occasion, my lord, that if they were in receipt of gratuity, they would have been. But now the only difficulty is that in this case, the petitioner, the husband of the petitioner, the deceased husband, never received pension at any point of time. So now she is coming saying that you issue the PPO in my deceased husband's name and then family pension in my name. There, my lord, is a difficulty. My lord, before the amendment, pre-amendment, there was some time in between when they could have, my lord, claimed, my lord, some that gratuity, if they were in receipt of gratuity, pension could have been. But now, my lord, here the difficulty lies because the husband had never come before, my lord, to the authorities or before this honorable court or any other authority, my lord, claiming for pension. Now, PPO, my lord, in the name of a deceased person and then family pension in a name, my lord, will create some difficulties, my lord. So this is where, my lord.
Suppose a person dies in harness where the pension has not been issued but has completed 1 year of service at the time of death.
My lord.
Then the wife will be entitled to get family pension. Then
This is one of 23(1) clearly mentioned, one of
Very well. Let's go.
23 family pension. Just have to do. 23 family pension. The family pension is admissible to the member of the family of an employee who dies while in service after rendering 1 year service. So first part, there is a clause. If the pension, the incumbent died immediately after completion of 1 year, the family pension is entitled. The PPO should be issued in the name of the employee. Then the family pension. The next two, the benefits shall also be admissible in case of death of an employee after retirement, if at the time of death he was in receipt of a compensation, invalid, retiring, or superannuation pension or gratuity. So, my lord, this is the 5 category. If the pensioner or the retired person had got, then even after my lord death, the family pension would be issued in favor of the widow. So this is one of the clause. So there is no, my lord, bar. But my senior learned friend is submitting that there is a difficulty. Absolutely not. Because of, my lord, the gratuity PPO was issued in favor of the employee. Thereafter, my lord, the employee died. the employee, my lord, received the gratuity in terms of 23/2. So, my lord, the family pension to be issued in favor of the widow, where because, my lord, the widow's name has, my lord, has already been indicated in the PPO. Kindly come to page 14. And, my lord, next page is typed copy. My lord, the serial number 9A, then, my lord, 10. The name Jayanti Jana, who is the petitioner nominee, full share, wife. So there is no difficulty.
Yes.
Before amendment, it's permissible. After amendment, it's not permissible. This is my only humble.
He falls within that bracket. There is no dispute, my lord, vis-a-vis that. My lord, just that only the delay, my lord, that my lord will decide.
My lord, a delay in respect of, my lord, the pension, my lord, lordship knows,
My lord, that very well, my lord. From my side, my lord, that is that.
By the present writ petition, a report filed by the state furnished by District Inspector of Schools PE Poschim Medinipur dated 13th July 2026 is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly District Inspector of Schools is respondent number?
Well, the District Inspector of School respondent number?
Particularly respondent number?
Well, 4.
4. District Inspector of Schools PE Poschim Medinipur to sanction the family pension in favor of the petitioner. The petitioner contains that her husband, late Santosh Kumar Jana, was a primary teacher of Shabra Maktab Primary School, Jhalda Circle, who retired from service on superannuation on 30th April 2002 after rendering service for a period of 8 years, 4 months, 18 days. Subsequent to retirement, pension payment order was issued in favor of the husband of the petitioner on 15 January 2004, allowing only gratuity amount of rupees 43,304 but without pension.
42304, madam.
42.
That's what, madam.
Gratuity amount is
42304, madam, as per my instruction.
42304.
304.
Huh? 42304, correct. This is wrong, huh? Para 4, there is a mistake.
Yes, it should be 42304.
42304. On 10th February 2007, the husband of the petitioner expired. The petitioner on, where is the representation?
Well, the representation page 16. And after P3. 18 June 2025.
On 18 June 2025, the petitioner submitted a prayer for grant of family pension in her favor before respondent number 4. However, the same has not been.
In terms of the DCRB scheme clause 23(2).
In terms of para 23(2) of the DCRB, death cum retirement benefit, in short DCRB scheme 1981.
Right.
However, no steps have been taken. However, the family pension has not yet been granted. Hence, this writ petition. Mr. Subhrangshu Ponda, learned advocate appearing for the petitioner, submits that though the husband of the petitioner did not complete 10 years of service, however, as per para 23(2) of the notification number 135 EDN within bracket B dated 15th May 1985 of the DCRB scheme 1981, since the deceased husband received gratuity, the widow is entitled to family pension.
That's fine.
As per the rules as it stood prior to amendment. What is the date of amendment?
My lord, amendment is, my lord, the 3rd July 2028.
3rd July 2028.
2008.
2008.
This is, my lord, amendment where the gratuity.
Mr. Loknath Chatterjee, learned advocate for the state respondents, submits that the husband of the petitioner was not granted pension since he did not complete 10 years of service. There was no prayer made by the deceased husband seeking for condonation of shortfall of service. There is unexplained delay on the part of the petitioner to seek for family pension. As such, in light of the above, he seeks for dismissal of the writ petition. Admittedly, the deceased husband of the petitioner did not receive pension since he did not complete 10 years of service. The question which is to be decided is whether the petitioner in the aforesaid circumstances is entitled to and and was only granted gratuity. Whether the petitioner, being the widow of the deceased employee, is entitled to family pension or not. In order to examine the aforesaid issue, it would be apposite to reproduce para 23 of the DCRB scheme 1981 as here under 1-2 quote করবেন. The aforesaid rule has been amended on 3rd July 2008, which is also reproduced here under. The husband of the petitioner died on date of her death.
My lord, the husband died on
February 10, 2007.
10th February 2007.
Yes.
10th February 2007, prior to the aforesaid amendment. Therefore, the rules as it stood prior to amendment is applicable in case of the petitioner. As per Rule 23(2), the benefit of family pension shall also be admissible in case of death of an employee after retirement if at the time of death he was in receipt of a compensation, invalid, retiring or superannuation pension or gratuity. There is no dispute that the husband of the petitioner received gratuity. In terms of the aforesaid rule, the petitioner, being the widow of the deceased, is entitled to family pension. Accordingly, the district respond number 4 is directed to take appropriate steps for verification of the records and forward the same to the DPPG
respond number 3
for issuance of pension, family pension in favor of the petitioner. It will be from which date?
From the date of the
submission of application.
No, from the date of death of the husband of the petitioner.
From the date of death. From the date following the date of death.
Yes.
Subsequent to that.
Subsequent.
Following the date of death. Following, man, that will be.
The concerned treasury officer.
Within a period of. No, not till the actual period. It will be sanctioned from the date following the date of death.
Following the date. And respond number 5, treasury officer also consequent steps to release them.
That will be given by the DPPG, no? No direction is required right now. If we sanction the pension within a period of 6 weeks from date of communication of this order, learned advocate for the petition had to communicate.
Yes, my lord.
Disposed of. 11:30 my lord.
One and two, my lord, I am both the respondent in that matter. My lord, after my lord, the lordship 8 May, my lord,
New
our
administrator has been
everything
appointed.
ceased. So, my lord, kindly
My lord, I
excuse
committed one mistake on the last occasion. My lord,
Yes.
I admit that in making submissions,
Yes.
that after the new government's order appointing army administrator, the first point become redundant. Your loss is recorded. That's I've committed a mistake that doesn't my lord, that does not become redundant. Why I just explained it to your lordship.
my lord, before my senior learned phrase, my lord, today I have no authority to. No, no, status. I mean,
Then now the nominated members that are
my lord,
terminated.
kindly excuse me because it is very, my lord,
No, you have served notice.
yes, I have.
everyone.
Because today I have no power. Lordship,
Okay.
in terms of my lord, the notice, the governing body is gone.
Nobody was not there.
So, my lord, I have. Kindly excuse me.
No, my lord, your lordships kindly consider the order last date I submitted before lordships 22nd May 2026.
Yes.
Now kindly see the very first paragraph. Whereas the tenures of nominated members of the governing bodies of the government aided colleges have been terminated by such and such order dated 12th May 2026 in pursuance of the Home and Hill Affairs Department dated such and such 11th May 2026. Therefore, my lord, my first submission would be tenures was for a particular period, tenures terminated, but their initial engagement or nomination has not been cancelled. Clear to your lordships. Therefore, during that period, they have they have functioned illegally, lightly, wrongly. My question was their very nomination. Therefore, nomination has to be quashed and their consequential act. Then, whereas owing to such termination, governing bodies of the government-aided colleges are not able to function properly to run the day-to-day activities in regular manner. Now, therefore, in order to restore the normal functionalities and in exercise of the power conferred by Section 4, subsection 3 of the Act of 2017, administrators are being appointed to the government-aided colleges in lieu of the existing governing bodies of the college. Well, kindly see. Administrators are appointed to the government-aided colleges in lieu of the existing governing bodies. But I will show to your lordships for finding while passing the interim order. The governing body is yet to be formed. Only 4 members were nominated. So, my lord, there was no managing governing body at all. And the administrators so appointed will be required to function as the same until reconstruction of the governing bodies of the colleges or until further orders, whichever is earlier. This order has the approval of competent authority and will take immediate effect. Pursuant to this order, the government kindly come to your lordships, serial number 197. Administrator has been appointed, the Joint Director of Public Instructions, and he has taken over the charge.
Now, if there is election for formation of the government body, those nominated persons will again be taken into consideration?
No, no.
Then what
They
is
cannot,
the,
when they phrase,
what is the
administrator has
import
to.
of using a language that tenures have been terminated?
Exactly, my lord. That's my lord. Tenures means I just take your lordships to the.
Was there any tenure in the notification
yes.
that they will be functioning
Nominated
for 1
members
year or 2 years?
Lordship, by the
Just a minute, let me understand.
Page 77, your lordships, the first, the WP number 20940, your lordships kindly take up.
2094 din na?
Hmm.
To Devnath Babu. 20 ওটা দিন। নিচেরটা নিচেরটা নিচের এইটা এইটা page 77
Page 70. Lord, your losses will find the following persons are nominated.
Hmm.
There is no fixed tenure. So long the governing body term will continue, they will continue. That's the presumption of law.
the following person you nominate persons
আর একটা কপি থাকার কথা অ্যানেক্স করা দেখুন আমার ফাইল থেকে বার করুন just my lord they have been nominated. Now your lordships kindly consider your lordships order dated 16th September 2025.
yes yes
Now I just your lordships has elaborately taken note of all the submissions, even your lordships the submissions of the then Advocate General and Advocate General, matlab, internal page 12 of your lordship's order, paragraph 14.
yes
Upon going to the earlier constitution of the governing body, at page 158 of the writ petition such and such, it is found that in the year 2021, the teacher in charge informed the Assistant Secretary of the Government of West Bengal Department of Higher Education of the constitution of the governing body and also disclosed names of the members. Upon query from the learned advocates for the respondents, it has informed and been informed that such letter has not yet been issued as yet. Then your lordships, such being the position, it is primarily seen that the reconstitution of the governing body is yet to take place. So your lordships kindly see the government order I produced before lordships in lieu of the governing body. So there is no governing body even. But these 3 persons or 4 persons used to run the college, suspended me, appointed vice principal. So my lord, now your lordships has to issue a writ of mandamus quashing this and all the consequential acts. It cannot be redundant. Because tenure, now I take your lordships to the act. Yeah, just a minute. Now, just a minute. Now your lordships, just section 4.1 and my lord, subsection and section 5, subsection 3. 4.1, my lord, your lordships, I submitted before lordships a copy. You're getting it? Now, the act
4.1.
itself,
Act
4.1.
probably it was
Copy
there
আছে লর্ডশিপ না আর
yes yes it will be there
খুঁজে পাওয়া মুশকিল এখন কোথায় মিশে গেছে
তখন দিয়েছে দেখো তো ওইগুলোতে আছে কিনা যেগুলোতে জাজমেন্টস এটা 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 হ্যাঁ এটাই হবে yes West Bengal
Section
Act
4, subsection 1. There shall be a governing body in every college to be constituted in the manner and procedure provided under the provisions of this act. Then your lordship, section 5 says who are the members, how to be constituted. Now your lordship, kindly subsection 3 of section 5.
yes
The tenure of the governing body shall be such as may be determined by the state government from time to time. Matlab, our tenure of the governing body.
it is subsection 3
3
of
of section 5.
the tenure of the yes
Exact. Now, therefore, your lordships, kindly recall your lordships, our submissions is very difficult because of passage of time. Our contention was that they were only nominated. There has to be an election in the teachers category, non-teaching category, and other categories. They have to be elected and presented before the governing body. Then the governing body meeting, all the members will call for and form the governing body. Probably your lordship has dealt with in your lordship's order, as just now placed before your lordships. Kindly your lordships, paragraph 16 of your lordship's order.
Okay.
I was placing paragraph 14 and 15. 16.
Annex করেছে। Petition এ দিয়েছে? Compilation এ দিয়েছে?
16.
16. Paragraph 16, internal page 13 of the order. Or running.
Yes, 16.
Further, the impugned notification dated 9 June 2025 has been challenged on the ground that the precedence as proposed is a councillor and cannot be a person interested in education as required under section 5 of the Act of 2017. Malad, normally I do not make these submissions. Mr. Bhattacharya also made it. Malad, he was the wife of the brother of the then ex-chief minister. Malad, this cannot be a consideration. Because I take your losses to at the name the entire elaboration of the provisions that this is not the person interested in education. Somebody's relative in the ministry cannot be a person interested in education just because he is the relative of a minister and is a councillor. Person interested means who has devoted his life for education, either being an educationalist or he has rendered such service for the education. That has to be proved. Where is that subjective consideration by the government before nominating him? That was our consideration, submission before lordship in a nutshell. Then it has been vociferously argued by the respondent number 7 and 10 to 10 that the said notification has not been challenged till issuance of so-called notice against the petitioner, and the petitioner has accepted the notification by issuing notice for holding election. Be that as may, Section 5 of the Act of 2017 provides that a president has to be person interested in education. Your lordships, in the impugned order in the nomination, your lordships will not find that he belongs to category of person interested in education. Because it doesn't, she doesn't. The government felt shy also to saying that. But if someone says I am educationalist, he should feel shy. I'm a practitioner lawyer. Unless somebody have some credentials in the field of education. So government also felt shy. He didn't mention it. Then your lordship, during the course of hearing, nothing is placed on record in support of such requirements of law. Therefore, the illegality of the said notification needs to be examination. In view of such circumstances, the court finds that an arguable case has been made out. Then your lordship state that operation of that nomination as well as this order of suspension dated your lordships. Just I give your lordships the date and page.
3rd July. 3rd July was the date of so cause and all consequential orders.
August 2025.
And all consequential orders of decision of proposal.
So therefore, today, I'm asking for the quashing of that nomination formally and the all consequential acts by the those.
Lordship, as per the Lordship order dated 22nd May of 2026, which has been already referred by my senior friend Lordship, this general body is no more in functioning, Lordship. Whatever may be there.
No, in this case, there was no general body.
Yes, Lordship. If want of quorum, even this is under disputed before this honorable court, Lordship. They are constitution of the GB, Lordship. But even if that is also not in functioning, they are not in even in the official, Lordship. So what I humbly suggesting before your Lordship that this GB is no more. So until the further GB is constituted, so that no decision can be taken by the present administrator, because they are the only appointed as an ad hoc basis, Lordship. So what I'm suggesting, if the Lordship may kindly observe that if the GB is constituted in the near future, they will take the further decision in accordance with the law, Lordship. Whatever the suspension or that allegation brought against the petitioner, if at all that will be taken by the next general body at all formed as per the Lordship statutes, Lordship.
Well, probably my learned friend has not understood my submissions. I'm sorry. What I'm saying, I have been suspended by a person
Who
who is
didn't have
not
the authority at that point
exactly
of
that must go.
Lordship, in that I should not, Lordship, submit
if
that.
if a general governing body is
Yes.
formed,
Yes.
governing body has to take steps in accordance with law
Law.
against A, B, C, whatever.
Yes, Lordship.
Might be the petitioner, might be some other person.
Some other person, yes.
That is left to the why a liberty has to be taken from the court to
Exactly.
take a process against somebody
And
who
though
is found guilty.
No, Lordship, not that. I just, Lordship, I should not submit that he, whatever her position was, that before this decision under the challenge before this in the writ petition, Lordship, that will be, Lordship, there if this GB is no more there. So that is, kindly don't record my submission, but that can be their Lordship. That is my instruction. That interim protection will be there for her, Lordship, till the next GB is constituted. GB, if once the GB is constituted, they will take the decision in accordance with law.
You file your instruction.
absolutely contrary to law.
If the administrative is there,
Lordship.
what prompted the state authority to place an administrator to this college? Why? You have recorded in the order dated 22nd May
Yes.
that there are found functionalities, there is some irregularity in the functionalities of some of the colleges, so we appoint administrator for the time being. So again, you are stating that there might be some allegations, we'll inquire on that. To have a,
That is need to take the decision by the subsequent GB, if at all form, Lordship.
And will be
That cannot be cartel, Lordship, because that is the
your lawsuit. I'm not asking for carteling somebody's right, but the order of suspension must go. It was
that I'm not on that, Lordship.
so what have you written in
Suspension,
your
Lordship,
instruction?
whatever will Lordship feel.
Order of suspension and the quashing of what he has prayed for, quashing of
Lordship, that kindly observe that. But this liberty that in
liberty is not necessary. You proceed.
kindly observe that, Lordship, that GB is at all formed, that they can perform in accordance with law against the any specific faculty member or whoever.
May I make one
Okay.
submission to
We cannot
clarify the law,
extend-
situation of law? Administrator is in lieu of the governing body. The administrator can also exercise all the functions of the governing body. What is the bar? Why my learned friend should wait for the governing body? My point is that
Kindly observe that, Lordship.
this need not be on my petition. My contention is that the order of suspension taken by a nominated president without having governing body, that's void ab initio. That should go immediately.
So
And
that
that's why your loss is steady.
that will, Lordship, that I am not that can go, Lordship. My instruction is that, Lordship. This nominated body.
I request my learned friend, don't repeat the instructions. We are lawyers. All instructions should not be said before your lawsuits. The law is clear.
Are you in support of the notification dated, what is the 9th June?
No, Lordship, I am not. This is otherwise, Lordship, that
If that nomination goes,
Lordship.
then the subsequent consequent
All-
steps
The take decision taken by this body
No,
will
if
go,
you
Lordship.
find the petitioner to be in fault in some of her functions in the college, that is left to the administrator. He will decide what for the administrator is there.
I just submitting that, kindly observe
Because in
that.
the
Lordship.
writ petition, the suspension is being withdrawn on the basis that the appointment was illegal. That is what is
That body,
submitted.
yes, Lordship. That
Not
nomination
the
was
merit
illegal.
that whether she should be suspended or so cause has to be given, not going into that merit. He says that since there were no government body, the president also was a councillor and not an educational person. So this nomination is incorrect. The quorum has not been formed. So there is no
There
governing
is no
body.
governing body either, my lord. But they took the decision.
Whatever, Lordship.
What was the prayer in the second writ petition?
As a suspension, quashing
Okay.
of suspension, and all consequential acts.
Okay. Shobur, anybody representing Mr. Shobusaji Chatterjee, he filed a CAN application. He filed a CAN application for issuance of salary to the staffs and all.
Now those have been regularized. Because of that impassable situation arose.
So this vice principal was appointed by the president.
Exactly. That should also, that should also.
By the writ petition being WPA 15396 of 2025 within bracket WP1 Roman 1, the petitioner has sought for quashing of so-cause notice dated 3rd July 2025 Annexure 7, as well as for quashing of notification dated 9th June 2025 being 375 EDB within bracket CS/4C-66/2020 Annexure P1. Para by the second writ petition being WPA 20940 of 2025, WP, in short WP2, the petitioner seeks for setting aside of the impugned order of suspension dated 29th August 2025 Annexure P4 and for setting aside of the purported order of appointment of vice principal, page number of that writ petition, sir, page number. Appointment of the vice principal, page number, vide number 624 dash EDN operator na 375 টা EDN হবে মনে হচ্ছে EDN CS/DP Roman 1-99/350 একটু order dated 16 September টা follow করবেন 2025
August 2020.
25th August 2025. Which is the annexure and page number. Annexure is
Annexure, I just one page number 132
132.
and annexure I give you also.
Para, the petitioner contains that she joined as principal in Rani
P6.
P6. Rani Birla Girls College on 29 September 22 when the college did not have a governing body, in short GB, and was governed by an administrator officiating from Department of Higher Education, Vikas Bhavan, Salt Lake City, Kolkata. The administrator got transferred and new administrator was introduced till the notice for formation of GB was issued. On 9 June 2025, respond number 3, Deputy Secretary, Department of Higher Education, CS Branch, Government of West Bengal, issued a notice to the principal of the said college to take necessary steps in the subject as mentioned in the said notification and furnish a report to the department at the earlier. By the said notification, the appointment of administrator made earlier on 16th March 2024 was cancelled. The notification dated 9th June 2025 does not depict that precedent is attached to any educational institution or does any work of the like nature which has direct bearing with education. Thus, the appointment of the president vide said notification is expressly bad in law. Mere nomination of persons does not constitute GB. First page show cause notice. In WP1, the petitioner challenges a show cause notice dated 3rd July 2025 issued by the nominated president within bracket proposed on the ground that such issuance of show cause notice is without jurisdiction. In WP2, the petitioner challenges the consequential order of suspension dated 29th August 2025 and also the order of appointment of vice principal, which is also without jurisdiction. Mr. Subir Sannal and senior advocate appearing for the petitioner submits that as per Section 5 of Act of 2017, না এর আগে করো at the outset submits that there is no governing body constituted in terms of the Act of 2017. The president who has been nominated has no bearing with education, which contravenes section 5(1) within bracket 1. He seeks for quashing of such notification on such ground. The order of suspension of the petitioner is also without jurisdiction. Since the nominated president, since the nomination of the president is in contravention of the provisions of Act of 2017. He seeks for setting aside of the order of suspension. The vice principal is acting right now?
No, principal is acting.
Okay. He seeks for appropriate orders. Mr. Swainso, learned advocate appearing for the state. You are appearing for? Okay. What is your submission? Okay. Learned advocate for the state submits that one administrator, Dr. Ashish Kumar Ghosh, has been appointed in the state college for the functioning, day-to-day functioning of the college affairs.
Public instruction, Mr. Ghosh. Can you mention?
Joint Director of
Public instructions. I find from the order itself.
Public Instruction has been appointed.
Joint Director of Public Instruction.
Joint Director. In the instruction they have stated.
Yes. Serial number 197, my lord. Kolkata Rani Birla Girls College, Dr. Ashish Kumar Ghosh, Joint Director of Public Instruction. In the order just like.
In the instruction, it is not mentioned, Lordship, but
Yes.
in the notification, it
Public
is mentioned.
Instruction designation. Joint Director of Public
Yes.
Instruction has been appointed as an administrator, and the tenure of nominated members have also been terminated. Para. Nothing in placed on record that the nominated president proposed in the notification dated 9 June 2025 is a person interested in education. Section 5(1) of the Act of 2017 clearly envisages that the president shall be a person interested in education and shall be nominated by the state government from amongst the members of the governing body or from outside. Thus, it appears that there is contravention in nominating the president vide notification dated 9 June 2025. As such, the notification dated 9 June 2025 is quashed. Consequently, the order of suspension issued by the president dated 29 August 2025 is also set aside. Now, who was the principal at that point of time?
But after suspending me, they appointed vice principal.
Who was?
He's a partner, Dr. Preeti Ghatani.
He has been removed.
He has to be, the appointment must be. Because I was enjoying interim order.
His learned advocates have been given notice?
Yes, everyone. Oh, Mr. Pandai was appearing. None of them are appearing.
All consequential orders passed by the nominated president also stands withdrawn. আরেকটা জায়গা উপরে নোট করে দেবেন, affidavit of service filed on behalf of the petition is taken, none appears on behalf of the respondents.
So instead of withdrawn, quashed your lawsuit, that should be.
All orders ওখানে যেটা
Consequential
act is deemed to be withdrawn. The writ petitions being number such and such stands disposed of.
Great.
একটু না? Thank you. এই যে গৌতম বাবু ওই হলো
No matter, no affidavit in compliance handed over, madam.
it has not been handed over as yet.
No.
Who appeared for the alleged contempt?
Madam,
দেখো কি তন্ময় মুখার্জি
Rohit Hajra, madam. Yes, sir.
তন্ময় মুখার্জিকে খবর দাও কি ব্যাপারে জুনিয়র সাবমিট করে যাচ্ছে আসছে না তন্ময় মুখার্জি
Rohit Hajra, madam.
রোহিত হাজরা দেখো অ্যালেজ কন্টেম্প রোহিত হাজরা বললো তো তন্ময় মুখার্জি অ্যাপিয়ার করবে একটু রাখুন পাসওয়ার্ড wait we'll call it after some time
Well.
Nick
Yes, madam. I have petition.
David research. My lord, petitioner is claiming family pension as a disabled son of a primary teacher. My lord, father of the petitioner died in 1975. That is prior to introduction of the DCRB scheme 1981. And due to non-grant of pensionary benefits, family pension benefit in favor of the petitioner, he filed a writ petition before this honorable court, and my lord, page 21. My lord was pleased to direct the district inspector of school. Operative part is part from page 22, paragraph 6, to take a decision
yes
in accordance with law, and my lord,
Thereafter, the page 24,
Family pension case as referred has been examined.
Directorate of Pension requested the district inspector of school for taking necessary steps in terms of the order of this honorable court. And my lord, next page, my lord.
Wait.
Page,
Wait. The PSA has been instructed to take a PSA means? Who is PSA?
Pension Sanctioning Authority, that is
Sanctioning.
the district inspector of schools.
District Inspector of Schools.
Yes, my lord.
Inspector take a decision on this in light of
Primary education, Paschim
yes,
Medinipur.
such as the PSA knows that the efforts of others has not been furnished. So why this
In
repeat?
terms of my lord's order, my lord, page 26, the district inspector of schools took a decision and after recommending family pension in my favor,
Yes.
forwarded the pension relevant documents before the
Director of
DPPG,
Pension.
Director of Pension for issuance of PPO.
Correct.
My lord,
Yes.
thereafter, my lord, page 27, the
Not
assistant director of DPPG, my lord,
Issue the notice to the respondent number 4.
requested
Malad,
the district inspector of school
issue the notice and PSA authority has been taken a decision, issue the notice upon the petitioner. But processing is going on. Malad,
DI has already taken a decision.
give me a 2 weeks time. Malad, what is the effect of the family pension? Malad, I inform to the authority concerned. Malad, then Malad, I shall file.
District inspector of schools already taken a decision in terms of my lord's order and recommended for granting family pension. So thereafter, my lord, raising any objection is harassing the petitioner, a disabled person.
Next week.
2 weeks time.
You take instruction,
My lord,
come back.
381 pension cases are
Yes.
heard
12
by
okay.
a larger bench decision, honorable larger bench decision, my lord.
Affidavit service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for a release of family pension in favor of the petitioner being a disabled son of the deceased employee. Mr. So-and-so, learned advocate for the petitioner submits that pursuant to order passed by the SCO in WPA 20486 of 2025, the pension sanctioning authority, namely the District Inspector of Schools P. Paschim Medinipur, has already recommended for grant of family pension in favor of the petitioner. However, the Assistant Director Pension Provident Fund and Group Insurance Company has Group Insurance, Government of West Bengal has not yet sanctioned family pension in favor of the petitioner. Mr. So-and-so, learned advocate appearing for the state respondent seeks accommodation to take instruction. 2 weeks accommodation to take instruction. Is this matter দুষ্ট হতে পারে?
My lord, under same heading, your lordship.
Under the
petition is
same heading, same
same
place
position, your lordship.
28th first 5 এর মধ্যে রেখে দিও।
Petition, I do not want to proceed with this matter, my lord.
Mr. Samimul Bari, learned advocate for the petitioner, submits that the petitioner does written instruction.
My lord, I don't have instruction, my lord. Some facts are not disclosed while filing this job. That's why I'm going to withdraw.
Bari, learned advocate for the petitioner, submits that certain facts had not been stated in the writ petition. Stop. Some relevant facts. Oh. No. What is your instruction regarding this? You have given your...
Yes, my lord. My learned friend, my lord, last occasion was told that earlier the petitioner approached this honorable court and the prayer of the petitioner was, my lord, turned down. That was not disclosed, my lord. That's why I took instruction. they said in that writ petition, a bunch of writ petitioner filed this writ application that was dismissed. Subsequently, some writ petitioner approached this honorable court. They got order. That's why they approached this honorable court, but that fact was not disclosed. So that's why I want to withdraw this writ application.
And what about the payment that has been made willingly?
No, that is relating to overdrawal, So I do not want to file this, proceed with the writ application. Let the overdrawal remain,
Oh. কি বলুন? Then this writ petition is misconceived.
Yes, my lord. Well, that was not disclosed by my client has not disclosed to me, my lord.
So
That's why I want to withdraw it, my lord.
The writ petition has been proceeded on non-disclosed facts. He seeks to withdraw this writ petition. In view of such submissions, the writ petition stands dismissed as withdrawn.
Next matter is also identical, my lord.
11 is also same.
Deeply.
Well,
I'm led by Kartik Kumar Roy. Due to some family medical emergency, he is not able to attend the court today. I'm praying for not today, my lord.
Exception?
Filed, my lord.
Release.
Lord, we are fine.
The report you have filed?
My lord.
The report is filed. No? The report is filed. They will be filing an exception to the report.
My lord, DI want to file the exception, my lord. One exception was filed.
Exception filed?
No, my lord, reply filed. And some reply filed by the DI. Want to file. Want to.
Oh. You have not filed any exception?
Well, we will file. My lord.
To the earlier one?
No, my lord.
Okay. Where is the report of District Inspector of Schools?
My lord, para number 5. Therefore, PPO was issued on such and such date. PPO number such and such, your lordship.
PPO has been issued?
My lord.
And what is the grievance? Interest? What are you claiming?
My lord, pensionary benefit. My lord, pensionary benefit with interest, my lord.
Release of the interest, your lordship, that is.
No, interest already released, my lord. We want to, my lord.
Interest released?
No, my lord, pension released, interest paying.
A report filed by District Inspector of Schools Primary Education, Purulia, dated 14 July 2026 is taken on record. Give a copy. Copy served. Learned advocate for the petitioner seeks to file exceptions, exceptions to the earlier report. Earlier report also you have not filed exception.
My lord, we already complete the exception, my
Have
lord,
you
but-
filed
No, my lord, I know.
exceptions to the earlier report of Special Director DPPG dated 4th April 2025, as well as the report of the District Inspector of Schools Primary Education Purulia dated 14 July 2026. Let such exceptions be filed within a period of 2 weeks. Place this matter under the heading hearing or motion. Hearing again. Place this matter after 2 weeks.
Date for my.
Thirteen, I am for the.
State. We are appearing with my learned friend.
You're appearing?
I'm for the state. And I'm learned with my learned friend.
You are
appearing with my learned friend.
Okay. This is for?
For family pension and lordship 1 month salary and PF lordship. So husband was the teacher appointed in the year 72. Lordship, there come to the list of debt lordship.
72.
Yes, lordship. That of lordship transferred another school and lordship on 25th August 86. Petitioner husband and along with 3 other person was brutally died. Brutally killed lordship by some other person lordship. Lordship, thereafter lordship petitioner has not been paid any pension, gratuity, PF and also 1 month salary for the month of August. Petitioner submitted sent representation lordship, that is annexed P11 page 37 to 42. Thereafter lordship petitioner requested to attend the hearing by the DI lordship, and petitioner attended the hearing, and on the request of the lordship DI, petitioner submitted application paying pension and before the DI, and on lordship 5th April 24, petitioner submitted representation before the chairman lordship, concerned chairman lordship, but till date lordship petitioner has not been paid pension, gratuity, PF and 1 month salary. Petitioner exercise option under ROPA lordship pension scheme lordship, that is option from lordship page 31.
Husband.
Husband exercise option lordship.
Yes.
Lordship. The petitioner husband died in year 1986. Thereafter, his elder son has given a post of a teacher on compensation ground. But he has not asked for pension till date, only 24, after 38 years. They asked for pension, delayed. But delayed by first question, paragraph P6. P6, can you see? After 38 years, 40, nearly 40 years. Yes, delay. Prayer for pension, gratuity, etc. for delay.
When did your husband die? In 86?
86. And he has filed application for 24.
24?
2024. That is after 38 years. Such a long delay. And I am coming from page 33. 53, can you see? 53. P6. District Inspector of Schools wrote a letter to the petitioner. Subject regarding the family pension of late Kalipada Basu. Hearing held on 3rd March, March in respect of application for short session, and he has requested to file some documents, particularly item number 5, statement why the application is applying for family pension after long gap with date of 1986 and 1924. This was not
Page number 36.
Page 53, P16.
P16.
P16. Hearing was taken, but he has required to file these documents to consideration of his prayer. Particularly 5.5. This
You
was
have
not
submitted document.
No, not submitted. From the record.
You have submitted
To me,
document.
I have submitted, Lordship.
What document?
The Lordship, next page.
You have submitted.
Affidavit.
Submitted on.
Not
Which
regarding
date did you
the
submit the
delay.
documents? When did you submit the documents?
Lordship, first Lordship,
Did you submit the documents as per letter dated 10th May 2024?
Yes.
yes, Lordship.
Where is that?
But I did not have the copy, Lordship, with me. I have.
So you have not received copy of this.
Affidavit, Lordship. Come to the next page and accept the receipt.
Clearly this. Annexure 16 is page 53.
My affidavit, Lordship.
59.
Thereafter, yes, sworn affidavit in respect of his death of his husband, wherein he stated that the certificate was not available to him, to her.
So you have accepted that affidavit.
Yes,
You have accepted that affidavit.
Yes, yes.
Accepted regard in respect of death certificate, not for the delay.
Lordship, for the delay, Lordship,
my
right.
What I am on, my lord, shortcut the matter, my lord. I am not against him. Yes, very well, my lord. Only they submit before them this document, particularly point number 5. Why the applicant is applying for family pension after long gap when the date is held in 1986, page 53, page 16. Let them file. Let them consider by the authority. But representation have given. Representation have been given. Let the representation and the
I have constantly pursued my case for receiving pension, Lordship.
Then
let them file. Let them consider.
Lordship, Lordship, my son did not get any appointment, Lordship, for compensation on the ground of compensation.
you got appointment.
No, Lordship.
I'm not on the point, Lord. It is a case for pension, gratuity.
Yes, Lord.
Now I am on
application for
that he has applied for pension on 2024. And person died in 1986 after long gap. Let them file the cause. And the representation already filed them. Let them consider altogether.
What is your submission?
I'm not in
pension case, Lordship. There is no third party right accrued, Lordship. It is my pension. Government is the duty to pay my pension.
Your prayer for grant of family pension has not been rejected.
Rejected, yes, my lord. Not rejected. Only
But
to consider
considered
the
by
document.
the authority.
Yes,
The consideration is still pending. Yet to be heard.
And if not filed, you file your documents.
Let them file the document. Let them consider.
You have filed.
Yes, Lordship.
So you consider on the basis of the documents that has been submitted.
No. On the last point, the statement why the applicant is applying for family pension after long gap. This particular point. Let's not file. Let them file and let them consider. I'm not on the way for getting pension. Let them consider.
Lordship, I relied
Why the application has been kept pending for last 2 years?
No, it's 24, 1924.
For 2 years, this application has neither been allowed nor been rejected.
No. Question of rejection, no. You has not filed yet the required document. Let them file the required document, let them consider within a short period.
What do you suggest? Or
I'm
keep
not
it
in
pending and get a
the,
report from
I'm
the
not bar,
state?
I'm not bar. I'm not standing the bar.
Do you accede to the proposal that has been advanced on behalf of the state, or keep it pending and call for a report from the state?
the report, kindly file, directed to file report, Lordship.
No. Did they file the document? Did they consider and file report?
You file report stating that the documents have not been furnished.
Yes, ma'am. Let them file.
And what is the stage of that application which has been considered and no order passed?
No. Could not consider because of not filing of the document. Could not pass.
Ash, you file a report. Let us see. Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner, by the present writ petition, the petitioner seeks for disbursement disbursement of family pension along with arrears in favor of the petitioner. The petitioner contends that her husband, Miss Swensul, and her advocate for the petitioner submits that the petitioner's late husband Kali Podo Baske, who was an assistant teacher of Domjuri Primary School, who was brutally murdered. No. Was an assistant teacher. Was an assistant teacher, joined as an assistant teacher. 3rd April 1972. The petitioner's husband was murdered on which year this?
86.
On
25th August
25th August 1986, while in service.
Yes, Lordship.
While in service. The petitioner on several occasions approached the authorities for sanction of family pension in her favor, and ultimately on 13th March 2024, the petitioner made a representation before the authority concerned for disbursement of family pension along with 1 month's salary of August 1986. Though the petitioner was called for hearing, but till date no order has been passed. State is directed to furnish a report on the returnable date. Please this matter after 2 weeks.
Last line. Direct. Dispose of.
After 2 weeks, file a report.
Report.
After 2 weeks, this will appear. 14.
This is the affidavit of service.
Yeah.
It has been served.
Served.
Yeah,
what is your prayer here?
Prayer for granting of pension. But it has been rejected by the commissioner on the ground of shortfall of service. But if your lordship takes note, recruitment process of 2000, I am giving the total facts. Thereafter, I am giving the dates, whether delay attributable to myself or delay attributable to the state. Only the issue has been decided by the Honorable Division in respect of self-same selection process matters. Now, can you take some notes? 2006 selection process.
You have sought for condonation of delay.
Yes, it has been rejected on the ground that I have not completed 10 years of service. At page 33, 34,
33.
it is communicated from the district inspector of school AC to my client. Kindly take in terms of no memo number such and such. Take to page 33 and 34 also. Shortfall of 3 years 24 days.
Which is the authority? Commissioner?
That commissioner is the authority for condonation, and thereafter it should be sent to the DI primary or thereafter pension sanctioning authorities.
Strategy you appear.
Judgment of our division bench is there.
We'll take
If
a
not,
note of, give a copy to him.
I'm giving.
Affidavit of service filed on behalf of the petitioner is taken on record. None appears on behalf of the state. Mr. Loknath Chatterjee, learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. Chatterjee be regularized by the concerned authority. Learned advocate for the petitioner is directed to hand over copy of the writ petition along with its annexes to Mr. Chatterjee, learned advocate for the state. State is directed to furnish a report on the returnable date. Is this matter? By the present writ petition, the petitioner seeks for seeks for setting aside of the memo number 108/pen capital /P dated 16 December 2024. This has been issued by which district
By
inspector?
the district inspector of school.
Respond number 4, district inspector of schools P South 24 Parganas. And for condonation of deficit in the qualifying service
of 3 years 24 days.
Of 3 years 24 days. After 2 weeks, Mr. Chatterjee.
My lord. May I hand up the judgment of the division bench to your lordship?
Not right
Not now. Kindly fix it next week so that it can be.
After 2 weeks, I'm calling for a report from that.
I'm handing over the judgment. This is settled by honorable division in respect of same selection process.
This is of 2009.
Not condonation of delay of more than 3 years.
2009.
Yes, 2006 election process, 2009 it was called for call letter, appointment given 2010, confirmed 2012, retired 2017. Same issue, because delay attributable to the authorities for 3 years for giving appointment. Single bench.
No, because my lord, remember, I believe my lord, these had the spirit of litigations also. So my lord, whether this will really fall on the authorities, my lord, this is something I will have to.
That is the
because they were, my lord, remember, 2009 there were a lot of litigations, my lord, concerning that.
Yes.
That came, my lord, much later in 2023 call letters were issued. So my lord, we will have
another aspect of another district. 2023 appointment letter issued, selection process 2003, my lord. Justice my lord, Tandon's judgment affirmed by the honorable.
my lord, I'm very grateful to you. My lord, here
matter may be fixed under the heading so that it can.
This heading also.
But I am anxious of regarding getting pension. Yes. Much obliged.
আমি দেখে নেব। না ঠিক আছে, আমি দেখে নেব, দেখে নেব।
Usually appears.
My lord, here, my lord, this matter related to that HRA issue. My lord, 15. বলবেন, আচ্ছা করুন।
Matter relates to HRA. The petitioner is a primary school teacher. Her husband is working in a private organization. From February 2024, the HRA of the petitioner withheld on the ground that the husband working in the private organization, he is also receiving HRA. This is settled law, my lord. This has been decided. The judgment, my lord.
না না মধু এখানে কি ডিপিএসসি হবে
And my lord, appeal was preferred. Appeal was also dismissed.
Justice Sarab's judgment.
Yes.
বাবু এখন মামলা করতে দাও, মামলার সময় তোমরা যদি
This is Justice Sarab's judgment. The issue was decided.
My lord, here, my lord, they had given a letter. My lord, here they had given a letter. তুমি ডিপিএস এর ইনস্ট্রাকশন আছে তো মামলায় বলছো কেন কেন করছো এরকম? My lord, here they had given a letter. My lord, the petitioner herself had issued a letter, my lord, asking for, my lord, stoppage of house rent allowance, because, my lord, here it is, although the my lord, the petitioner may say
Yes.
my lord, now, my lord, here they may come and say, my lord, it's covered by Madhumita Bishwas, my lord, the other decisions. My lord, after, my lord, here this letter was issued, pursuant to this letter issued by the petitioner, my lord, HRA was stopped, saying that, my lord, because her,
Both of us are receiving.
my lord, and there was that, my lord, memo at that relevant point of time, my lord, here, this is, my lord, the 20, my lord, which was considered later on in Madhumita Bishwas. একটু judge সাহেবকে দিয়ে দেবেন। হ্যাঁ হ্যাঁ মৌসুমী বিশ্বাসে কনসিডার করা হয়েছে। But I'm sorry, my lord, I just have one copy, my lord. So this was 12-18 দুটোই কনসিডার করেছে মৌসুমী বিশ্বাসে, সরি। হ্যাঁ
Yes.
So my lord, here, although my lord, sorry, my lord, Moushumi Bishwas, this point, my lord, and few other decisions, my lord, because if in the private sector, my lord, the difficulty was created because of this letter of the petitioner. So subsequently, my lord, the petitioner had issued a representation later on, my lord, saying that that was issued under wrong pretext and all, that was done. My lord, that letter is at page 27, where they had issued a letter to the chairman, my lord. My lord, paragraph 3, there is an admission. This creates a bit of a difficulty, my lord. Yeah.
Paragraph 3.
At page 27, my lord.
18th January 20 wrote a letter. You're stopping for HRA as we have.
My lord, here.
Yes.
Now, my lord, if my lord will be pleased to advert to the letter of my lord 18 January 2024,
Yes.
my lord, the second unnumbered paragraph, my lord, as of July 1, my lord, the letter of 18 January, which I just handed over.
Second page. Which page?
My lord, that letter, my lord, which I just handed over. I'm sorry, my lord.
Yes.
Yes, my lord, the second unnumbered paragraph. As of July 1, 2021, my husband has been receiving rupees 16,400 as house rent allowance. Due to certain changes in our circumstances, I am writing to request the discontinuation of my house rent allowance effective from January 2024. So, my lord, what is this change in circumstances, my lord? That is not.
Okay. Yes. You have not disclosed in the writ petition of this letter?
Yes, yes, I have disclosed. I have
No, a letter to annex current.
Why?
Letter has not been annexed.
Why the change circumstance was from January, my husband got the employment and he was receiving HR. Now, the head teacher of the school told that you are not entitled because your husband is. She was not aware of this judgment. Then she wrote a letter. My lord, thereafter, she came to know that since he is working in a private organization, the petitioner is entitled for full HR. Then she again wrote another letter and prayed for withdrawal of that 2024 letter. But in accordance with law, my lord, she is entitled. So, my lord, kindly direct the authority, my lord, to pay the HRA. According to the law, my lord, she is entitled now. And I have disclosed in my writ petition also, my lord. It's not that I am suppressing anything.
It will be from which month?
From February 2024.
Which paragraph of this judgment this has been stated?
My lord. And it comes to my lord. Paragraph 49, page 38, if you'll also kindly have a look, my lord. In view thereof, the state respondents are directed to ensure complete conformity in the payment of HRA, which is payable to the petitioners in accordance with the ceiling envisaged in RUPA Memorandum of 2009, which is applicable to them, along with any connected memos that may be applicable. If in any case, The payment of such HRA has been stopped in pursuance of memo dated 2017 and 2012 or other similar memos that have been issued by the various district inspector schools across the state. The arrears of the same must be paid to the petitioner within 6 weeks from the date of this judgment. So these notifications said, my lord, if one of the spouse is working in private organization is getting HRA, so other spouse is not entitled for full HRA. So that has been clarified here. My lord, Honorable Court has specifically said paragraph 48, my lord, the details have been stated there. And similar order, my lord, I have annexed with the writ petition. If you lordship kindly have a look at the last annexure. The coordinate bench has passed order, my lord. Page 13.
Yes.
Only the paragraph 6 will be corrected because the appeal has been dismissed also.
Yes. A report filed by the state furnished by District Inspector of Schools dated 8 July 2026. P. District Inspector P. Aura is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities to pay the current HRA, house rent allowance, HRA in short HRA, as well as area HRA amount, which is accrued in favor of the petitioner from the month of February 2024 till date, along with interest immediately. The petitioner contains that he is an assistant teacher of which school?
Shatoshi Primary School.
Shatoshi Primary School, GIP Colony, Jogasha Circle, District Howrah. The petitioner joined in the said school on 21st January 2014. Since her joining, the petitioner was receiving house rent allowance. However, all on a sudden, the house rent allowance of the petitioner was stopped from February 2024.
My lord, prior to that, her letter came, my lord, 18 January 2024.
Even I have stated.
7.
Yes.
Not pursuant to her letter, it was stopped, my lord. Not all of a sudden.
Pursuant to why do you write in para 6? In para 6 of the writ petition, you have stated that suddenly the HRA has been stopped, withheld from February 2024.
Well, that they've stated, my lord. I don't know, my lord, why. My lord, it was after her letter that it was stopped.
Pursuant to letter of the petitioner dated 18 January 2024, the HRA was stopped from February 2024. In the writ petition, is there any contention that out of wrong conception that later was you have stated?
Subsequently, the petitioner realized that she has committed mistake, and by letter dated 14th July, she made further.
Which paragraph?
I think, my lord, paragraph 7, I believe.
7. Stop. However, realizing her mistake, the petitioner submitted a letter before the concerned authority on 14 July 2025 for releasing her HRA from the month of February 2024. However, since the same was not released, the petitioner has preferred the present writ petition. Mr. K. M. Hossain, learned advocate for the petitioner, submits that the husband of the petitioner is working in a private organization. Therefore, the household HRA of the petitioner cannot be withheld by the authority on the ground of employment of the petitioner's husband in private organization. To buttress his contention, he relies on the decision of a coordinate bench of this court passed in Mousumi Vishwas and another versus State of West Bengal within bracket re WPA 1389 of 2018 along with bracket close along with other batch of writ petitions. He seeks for release of the current HRA as well as area HRA together with interest as well as arecta decision bolo Payal Banerjee versus the State of West Bengal WPA 519 of 2023. On the contrary, Mr. Loknath Chatterjee, learned advocate representing the state respondents, submits that the HRA of the petitioner has been withheld on her own application. It is not the action of the state which has culminated into the grievance of non-payment of HRA. Therefore, the stoppage of the HRA cannot be attributed to the state respondents. In order to examine the issue involved in the present writ petition, it will be apposite to reproduce 48 and 49 of Mousumi Vishwas Supra. In Payal Banerjee Supra, a coordinate bench of this court, considering the decision in Mousumi Vishwas Supra, has also passed orders for release of HRA. In line with the aforesaid decisions, the which authority will issue the which respondent?
The respondent number 7.
Respondent number 7
shall calculate it and it will be forwarded to the
respondent number 6.
Yes.
District Primary School Council Howrah is directed to calculate the arrears of HRA and forward it same to the
Commissioner of School Education. Respondent
for
number
Commissioner
3.
of School Education, respondent number 3.
And after his approval, my lord, it will be released.
For disbursement of the same in favor of the petitioner, the payment shall be made within a period of 6 weeks from date. It is informed
date of communication, my lord.
from the date of communication of this order. It is informed that the appeal being met 1023 of 2021 against the judgment passed in Mosumi Biswas Supra has been dismissed by the Honorable Division Bench.
ওটা হ্যান্ড ওভার করে দিন।
এইটি করবে বুঝলে, এই 12টা করবে for the purpose of complying the aforesaid order, school authorities এই করবে।
My lord, essentially, my lord, it was dismissed for default, my lord.
It was dismissed for default.
Dismissed for default, my lord, till date not restored. I do not know whether restoration
Has
application
been
has been.
dismissed for default on
My lord, on 4th of December 2025.
4th of December 2025. It is informed that there is no such a restoration of the appeal as on date.
My lord, one line, my lord, that they will not be entitled to any interest, my lord, because it was on their own application.
It is
না না পরে আবার এসে
was not allowed together with complete arrears. Interest were not applied in HRA in the earlier orders also.
It's not,
No,
but
only,
my lord,
only
they
I'm praying for HRA. I'm not praying for
Arrears of HRA.
areas of HRA, my lord.
So interest is not
My lord,
mentioned.
because my lord, they've prayed for interest in paragraph in prayer A. That is why, my lord, just that my lord is not allowing the prayer.
No. Only the arrears. To be
So my lord will no need to, my lord, indicate that in the order, my lord.
Only the arrears.
Okay.
Yes.
And for the petitioner, my lord. My lord, in 16, 17 and 18, my lord, earlier state was not present. So for the information, I was directed to file affidavit, my lord. As now state is present, kindly allow me to serve copy on them, then they will file the report.
Why you are not appearing? 30th June you did not appear. Where is your supplementary affidavit? Where is the supplementary affidavit?
My lord, that information is not available, you know, unless and until state is filed their report, my lord.
Oh, you have sought to file supplementary affidavit in order to annex the pension payment order of the deceased.
PPO has been annexed, my lord. Only delay payment interest is my prayer, my lord. Interest on delay payment of family pension.
Yes. Why this has been stated? Has been retired on
Retired and PPO was issued earlier on 13th December 2001, my lord.
This PPO has not been annexed. That's why I have asked you to annex that.
First issue PPO, my lord, not available. Already petitioner's father also died, mother also died, my lord. Kindly-
Petitioner is the daughter.
Daughter, widow daughter, my lord.
So page 12 is the pension granted to the mother.
Mother,
You have no copy.
no copy.
So you'll not be filing any supplementary.
This is why. So once state will file report, my lord, I can able to
Okay.
file this.
Mr. Dinesh Pani, learned advocate for the petitioner, submits that the pension payment order of the deceased employee is not available with his client, and therefore his client will not file any supplementary affidavit in terms of order dated 7th April 2026. Could not correct. State his title furnisher report on the returnable date 2 সপ্তাহ পর, after 2 weeks. You have a copy?
No, copy.
Yes, copy.
Copy you have given?
Start, my lord.
Copy of the writ petition and its annexure has been handed over to the learned advocate for the state.
Same order for next two also. Item 17. And for the petition.
Eighteen, same order.
The same one, 6-seater.
17.
16 to 20.
16 টা কল্যাণী 16
আচ্ছা
ফার্স্ট এটা লাস্ট
Deep.
I am for the petitioner lordships.
This point has cropped up, Lordship. I am directed to find out this second wife has come to picture to get the family pension. During the lifetime, the already he had married. That first wife had no objection, has not been raised against the second wife. The husband already used to work in the government service. Nobody raised any question. The employer, as regards the second marriage of the husband, and lifetime he had already with the second wife. He has spent the life with the second wife. First time nobody raised the objection. Then after retirement, the already first wife enjoyed the pension. He had died, and the first wife had been nominated, and second wife has come to picture lordship to make an application for family pension.
Rejected.
Rejected on that ground, lordship. Yes, the taken a plea has been taken, the bigamy ground, the second marriage. Lordship, I have shown one judgment, Lordship, that
What is
during
this?
the lifetime.
What is the rule governing the pension regarding second wife?
Lordship, I'm sorry. Widower, Lordship, note kindly.
Yes. This is a bar.
That is why I'm paying for time only for 2 weeks, Lordship, to searching the another job. Lordship, find out the one judgment, Lordship. This is the creating the Lordship, the kindly look into this judgment. The matrimonial relationship continuously first wife accepted it. The after retirement, Lordship, the at bottom paragraph undoubtedly indisputable, the first wife, the Putul was the Sriram expired on 4th January 1978. Sriram married Sushila on 11th February 1972. Sushila gave birth to a female child on 4th February 19. Sriram entered into service of 18 July 1991 and expired on 13/7/2000. On the death of the Sriram and Sushila was the sole surviving widow, and the matrimonial relationship among the Sriram and Sushila was of the about 30 years, and such subsisting matrimonial relationship has also not been disputed by the petitioner. From the said facts, a presumption arises to the effect that there was a valid marriage among Sriram and Sushila. Such presumption, however, is a rebuttable one, but the evidence required to rebut such presumption cannot be an evidence of mere probabilities, but it should be an evidence to prove conclusively that the possibility of the such valid marriage is completely ruled out. In the instant case, the matrimonial relationship Sriram and Sushila was not the challenge by Putul, not even a complaint was lodged by the Putul for taking any disciplinary action against the deceased employee. The employer, being a third party, cannot initiate any proceeding seeking declaration of pertaining to the validity of the matrimonial relationship among the Sriram and Sushila. The employer also did not penalize the deceased employee on the charge of bigamy, though it was within the knowledge of the employee that Sushila was the second wife of the Sriram Putul son, namely Sanjay. And this conspectus, Lordship, this observation that at the lifetime nobody raised objection, employer did not initiate any proceeding. After retirement, he had left this world. Then employer raising this question, relationship has stood extinguished. This is the observation of this case. This is presumption, this is the valid marriage. Nobody raised question, lifetime. They accepted first and second wife. Employer did know everything. No disciplinary proceeding initiated against him, against the employer, by the employer. Then after retirement, he left this world. The relationship extinguished. Then employer raising this question. This is the second marriage, one not intended.
My lord, law is very clear in only to your lordship that under section 17 of the Hindu Marriage Act 1955, second marriage solemnized during the lifetime of the first wife is void.
First wife died on after the death of the deceased employee.
Lordship, prior to.
Prior to.
Thereafter, the husband had died.
But such second wife.
Right.
The first wife died lost 18/8/2023.
First wife.
First wife.
And the deceased employee died on?
Deceased employee died lost
On
the
4th.
date for 2022.
After then, wife dies after.
Lost.
So on the date of death of the deceased employee, both the wives were alive.
Both
My
the
lord.
were
In the case which we have cited, come to page 6th page.
Lordship, at the inception, it needs to be stated, we do not agree with the finding of the Leibniz table to the effect that under the pension rules, there is a differentiation between a first wife and a second wife, and as such, irrespective of validity of the matrimonial relationship, the settlement dues of the deceased employee would be payable more widows than one surviving after the death of the concerned employee. In the event that the presumption relating to their matrimonial relationship can be rebutted by conclusive evidence by either party, thereto against the other party to the marriage, the second wife with whom marriage was solemnized during the subsistence of the matrimonial relationship with the first wife would certainly not be entitled to family pension. Furthermore, such an issue is not involved in the instance of the first wife did not initiate any proceeding against the matrimonial relationship among the Sriram and Sushila, and that the court will not adjudicate issue. We do not arise strictly on the facts and the presented before this court. The judgment relied upon by the learned tribunal and pertaining to the maintenance under section 125 of the Code of Civil Procedure, and also not applicable to the facts of the case in as well as the provision towards the maintenance that we enacted and the social justice, and especially to the protect women and children, and also old and inform the poor parents, and the falls within the constitutional sweep of the Article 15.3 and reinforced by the Article 39 of the Constitution of India. The provision gives effect to the natural and fundamental duty of a man to maintain his wife and children and parents so long as they are unable to maintain themselves. These provisions are applicable and enforceable whatever may be the personal law by which the personal concerned are governed. This 6 paragraph. 6th page. The social justice law. One can be
two decisions of this court is standing against your prayer. Correct?
Yes.
The decisions are one of Seema Chakraborty and Niru.
Ruby.
In Niru Devi.
Niru Devi.
These two judgments are against you. The court has distinguished that judgment because on the death of the deceased employee, both of them were alive. Huh? Which was not the fact in the case referred here.
My lord.
But Seema Chakraborty and Niru facts are similar to your case. Where upon demise of the deceased employee, both the first and the second wife are alive. Second wife is the petitioner and the first wife died in 2023.
2023.
And the employee dies in 2022.
My lord.
So upon death of the deceased employee, both the wives were alive.
My lord.
So Seema Chakraborty and Niru will apply in your case. And the rules as he is indicating the rules.
My lord.
I have handed over this.
We have already submitted our report.
Yes, Mr. Then what we will do?
Last chance I will try otherwise. Last chance I will try otherwise.
29 রাখো দেখি
Two
এটা কি
weeks.
বলে। Not today then. Find out.
My lord, kindly order be kindly order be directed, your lordship.
Yes, yes.
Not today, not today. Next week.
Next week it will come up.
Next week.
What do you want, Mr. Singh?
For our presence, your lordship, kindly order.
It's a line, my lord, for his benefit.
Just not today. Take it next week.
My lord.
Thank you.
Deeply grateful.
দাদা
May I permitted for mentioning, my lord, item number 4, your lordship pass over this. My lord,
Pardon me, my lord, I was trying to contact with the contemner. I was trying to contact with the contemner. I cannot connect, my lord.
For whom you have taken passover in the morning?
Senior, on behalf of the senior. On behalf of the senior.
What is his name?
I'm led by Mr. Jha.
Jha. What is his full name?
Mr. Bojes Jha. Mr. Bojes Jha.
Ask him to come. You have taken passover for calling this senior. You submitted before the court that he is busy in some other court. I gave you passover. Now where is your senior? Where is he?
But he has left for the court.
Now he has left the court. What are you submitting? Why did you take a passover in the morning? You could have said that the affidavit in compliance is not ready.
My lord,
You have kept him busy in the court, this court. Twice the matter was taken up prior to the rising of the court. You were not there. Now you say that your senior is not there. You have not communicated that you have taken a passover for his appearance before this court.
Pardon me, my lord.
What pardon? You have not stated to your senior that this matter has been taken up, passed over. You are not advocate on record to say that the affidavit in compliance is not ready. What is this going on? The friend will wait for the all throughout the day for one matter to be taken up, contempt application. You keep him waiting for so long. Now you say that your senior has left the court. Ask him to come. Submissions. What is your name?
Rohit Hajra.
Awesome. By order dated 14th May 2026, the alleged contemner was directed to file affidavit of compliance. Para. On 7 July 2026, accommodation was sought for on behalf of the alleged contemner to file affidavit of compliance. Such affidavit of compliance has not been filed this day also. Alleged contemner Dulal Mollik is directed to remain present on the returnable date. Serve a copy of this order. Let a copy of this order be served upon the alleged contemner. Ask him to remain present on the returnable date. Release this matter after 15 days. 2 weeks.
Grateful.
Time to what time to 2 weeks 28th na 28th July 2026 at 2:15.
My Lord Advocate on record, Mr. Solil Kumar Maiti is ill. My Lord paying for only not today.
Accommodation is sought for on the ground of illness of Mr. Sholil Kumar Maiti, learned conducting. On the last date also you sought for accommodation. Learned conducting advocate for the petition. You have submitted the documents.
I don't know, my lord.
When he will join? After surgery. Release this matter after 2 weeks. After 2 weeks.
After
21. ये तो पहले दिन तो
My lord, petitioner retired from service, my lord, 31st December 2000,
31st
December, my lord, 2008, my lord. He paid for Rupa 2009, page 16 and 17. That was paid, my lord, on 2025, my lord. But no interest was paid.
interest.
Yes, ma'am. Rupa 2009 paid, my lord.
Arrears.
Uh,
Interest on arrear and gratuity or only arrear?
Payment was made, my lord, 2.5 months later, my lord, from the date of retirement. Paragraph 3, my lord, page 3. Date of retirement, my lord. Rupa 2009.
First pension payment order was issued on
17 March 2009, my lord. Paragraph 4.
Revised pension payment order.
Order issued on 13 September 2025, my lord. That was instruction, my lord.
And arrears instruction. Where have you stated that?
My lord, during pendency of the writ petition, my lord, that letter was issued.
Where is that?
This is the letter. Instruction. ওই আমাদের যেটা ইনস্ট্রাকশন বলছে ইনস্ট্রাকশনটা আমাদের দেওয়া শেষ আপনাকে দিয়ে দিন
Yes.
My lord, this instruction.
এইটা ওনাকে দিয়ে দিন। Arrears under ROPA 2009 was calculated from which period? 1st January.
Of January 2009.
1st January 2009. ROPA effect has been given from which date?
My lord, 1st January 2009, my lord.
January 2009. Asun. By the present writ petition, the petitioner seeks direction upon the respondent authorities for grant of interest on delayed payment of gratuity and arrear pension, together with interest at the rate of 18% per annum. The petitioner contains that he was an assistant teacher of Sahara 2 Primary School, Post Sahara District, Purbo Medinipur, Agra West Circle. The petitioner retired from service on superannuation on 31st December 2008. The first pension payment order was issued on 17th March 2009. The revised pension payment order under ROPA 2009 was issued on 13th
September, madam.
13 September 2025.
Hmm.
The revised gratuity and arrear amount was disbursed to the petitioner on which date it has been disbursed?
My lord, thereafter disbursed, my lord. During pendency of the writ petition, my lord, this was issued 17th March 2000. Sorry, my lord.
Where is the pension payment order? 98 years.
My lord, page 15, first PPO, my lord.
When was the arrears revised gratuity and arrear was disbursed?
My lord, that was not.
It has not been disbursed.
My lord, disbursed, but no date has been furnished by my client.
Which paragraph you have stated that it has been disbursed?
My lord, during pendency of the repetition, they disburse it.
When?
My lord, 13 September 2025, my lord. Instruction was there.
13 September 2025 is it
Yes,
revised pension payment order was issued.
Yes.
When was the arrear and gratuity granted? Released in your favor?
Yes, my lord. That was 17 March 2009, my lord.
17th March 2009 is the first PPO.
Yes, my lord.
The revised gratuity and arrear pension has been disbursed on which date? It has been disbursed.
Paragraph 6, your lordship, that concerned treasury officer may disperse the arrears after getting approval from the DPPG, your lordship. This is the report.
Then they say that they have not approved. You say that you have received. Take proper instruction, not today. Take Mr. Singh, you take back the report on the next day you file. Take proper instruction whether they have received, on which date this has been received.
I am for the petitioner, my lord.
But I am for the state.
Petitioner retired from service, my lord, at the 1st October 2020.
1000?
Pension payment.
Date of retirement 2020. This is ROPA 19?
19.
19.
ROPA 19?
19.
Where is the pension payment order?
Page 9, P1.
No, the revised pension payment order.
This is only the, I don't have instruction regarding this.
Not only one pension PPO.
Single PPO.
Yes, madam.
Ashun. Affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the respondent authorities for grant of interest on gratuity only.
Yes,
Interest on gratuity, yes.
Interest on gratuity
But the
at the rate
interest
of
is
18% per annum.
interest sought for is really high.
Yes.
Interest sought for is really 18%.
18% from date of retirement till such payment.
Till such payment was made on, as per
Just-
them, 21/6/2021.
Petitioner contains that he was a headmaster in Billogram HSFP school, district Nodia. The petitioner retired from service on superannuation on 31st October 2020. The pension payment order was issued on 15 June 2021. The gratuity was disbursed on which date?
21st of June
2021. However, no interest was paid, hence this writ petition. Mr. So and so, learned advocate for the appeal, submission time. The state leaves the matter to the discretion of the court. From the contention made in the writ petition, it is found that the gratuity has been disbursed belatedly. Accordingly, it is a bounden duty of the state to disburse the pensionary benefits forthwith upon retirement. Accordingly, 8%, 8 weeks from the date following the date of retirement till the date of actual payment disposed of.
It's my duty to only show
Yes.
Paragraph 9, my lord. In the averments, they have said that your petition is entitled to get interest
10%
on the total retirement benefits at the rate of although
no.
the other.
We'll go by the prayer.
Yes.
The gratuity.
8%, my lord.
8%, 8 weeks you disburse it.
Much obliged.
I am for the petitioner.
I am for the state.
And the petitioner declared on 31st October 2019.
19.
Pension payment order was issued on 24th December 2020. Payment was made 12th January 2001. First PPO. Second PPO was issued on second PPO issued on 27th January 2002. And payment was made 2nd February 2022.
22.
Retired 31st October 2019. First pension payment order was issued.
No, you retired from service.
December.
This is ROPA 2019.
Yes, my lord.
Revised.
Both are delayed.
No, both. This is also interest on gratuity.
Yes,
ROPA 2019.
Not only that, my lord, petitioner appeared on 31st October 2019. 2 PPOs issued. My lord, first PPO issued on,
There is no prayer.
my lord, 24th December.
There is no prayer with regard to any delay of 2009. ROPA 2009. PPO has been issued under ROPA 2009. That is the first PPO. The prayer is only in respect of 2019. Go through the prayers.
My lord, kindly allow to correct.
There's no question of correct. What is the averment? When was ROPA 2019 issued on? 20. Ashwin. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction for responding authorities for grant of interest on gratuity as per ROPA 2019 at the rate of 18% per annum from the date of effect of ROPA 2019 till the date of actual payment. Petitioner, you are for the state. What is your submission?
And I have no instruction.
Petitioner contains that he retired as head teacher from Dharmoda Charuchandra Primary School, District Nodia on 31st October 2019. The first pension payment order was issued on 24th December 2020. The revised pension payment order under ROPA 2019 was issued on 27 January 2022. The revised gratuity amount was disbursed on 2nd February 2022. However, no interest was paid, hence this writ petition. ROPA just submission. 14th February 2020. No, it retired was 2020. 14th February 2020 till the date of actual payment. 8%, 8 weeks. Disposed of.
I am for the petition.
Now for the DPSC Uttar Dinajpur.
My lord, the petition relates to payment of arrear amount of pension after treating the service of the petitioner under A category teacher. Now, my lord, the fact behind this case is this: in 1978, the petitioner obtained B.Ed degree in first class. In 2000, she was appointed in a primary school. Subsequently, in 2003, she was transferred to another primary school. In 2013, March 2013, she has retired. Now, my lord, she prayed for A category, treating her as a teacher under A category, that has been rejected. Challenging that, this writ petition has been filed. Before this, my lord, another writ petition was filed before this honorable court, and the Honorable Justice Amrita Sinha directed the petitioner to serve a comprehensive representation, and the concerned authority was directed to dispose of that representation. Accordingly, the representation was made, and my lord, that has been rejected. If your lordship kindly come to the rejection order, that is at page 33. Page 33, middle portion, slightly lower. It starts, whereas as per order of the School Education Department bearing memo number such and such dated 4th March 2013, teachers who possessed B.Ed degree and appointed before 1/1/2012 and subsequently completed 6 months bridge course from NCT recognized institution in elementary education may be allowed A category scale of pay. On the petitioner, that bridge course she doesn't have. That is why that is the sole ground of rejection. Now, my lord, my contention is this: if your lordship kindly come to page 19, it says in continuation, that is the representation of the petitioner before the concerned chairman.
You are not trained.
B.Ed qualification I have, first class B.Ed.
Did you pass B.Ed?
1978.
1978?
1978 with first class.
Where is that certificate?
That is at page, my lord.
You completed B.Ed in
Page
Engineering, but you
15,
joined as an 2000.
Page
But
60.
you were appointed right to
16.
Yes.
That is the B.Ed degree, my lord. And if you lordship kindly come to page 19, that is the representation of the petitioner before the concerned chairman, secretary, district private school council. Here it refers one circular, that is GO number such and such, dated 31st May 1996, issued by the Joint Secretary Education Department. It says that all primary teachers whose qualification is MABT, BABT or B.Ed can be treated as an A category teacher. So that is the circular or guideline of
page
the
number? Page number?
Page 19, 19. The first two paragraphs.
When you have been literally further informing that eligible for
So in terms of that circular, my lord, I am entitled to get
Where
A
is that
category
circular?
scale. Now, my lord, if your lordship kindly come to
let me check circular 1996. You have a copy of that? You have a copy?
No, my lord. Right now, I don't have.
Okay, continue.
Next, my lord, if your lordship kindly come to page 28, that is the continuation of page 27. That is one circular dated 4th of March 2013. So this circular has been banked upon by the concerned respondent while rejecting my prayer. Here, if your lordship at page 28 come to clause 5, it says teachers who possessed B.Ed degree and appointed before 1/1/2012 and subsequently completed 6 months course from NCT recognized institution in elementary education. So this has been referred in the rejection order by the concerned respondent. Now, my respectful submission before your lordship, if your lordship kindly sees that it was issued by the Joint Secretary, Government of West Bengal of the concerned department. Now, your lordship kindly come to page 24. That is the circular of NCTE. Page 24 of my writ petition. Now, it says, F number such and such in exercise of the powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009, 35 of 2009, and in pursuance of notification number such and such dated 31st March 2010, issued by the Department of School Education and Literacy, Ministry of Human Resource Development, Government of India, the National Council for Teacher Education, NCTE, hereby lays down the following minimum qualifications for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in clause O of section 2 of Right of Children to Free and Compulsory Education Act 2009 with effect from the date of this notification. Now, 1. Minimum qualification, classes 1 to 5. It says senior secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education. Now, within bracket, by whatever name known. So, this circular was issued in 2010. Now, my lord, the petitioner was appointed in 2000, in the year 2000. She joined the school. Now, she passed the B.Ed examination in 1978. So, at the time of appointment of the petitioner in the school, my lord, there is no such guideline. So, there are two things which are covering my case. Number one, this notification of issued by the NCTE, this is of the year 2010, and it says that whatever name it is known, elementary education, whatever known. So B.Ed, my submission is this, B.Ed, obviously a training course for teaching purpose, number one. And number two, my lord, as I referred before your lordship, that notification of 1996 of the state government, which I could not provide to your lordship right now, it says that all primary teachers whose qualification is MABT, BABT, B.Ed can be treated as an A category teachers.
You have completed the bridge course?
No, I don't have any bridge course experience.
No, you have completed 2 years course.
2 years B.Ed course. So I am lacking that qualification, what they are asking for. But my submission is this, that qualification, the extra qualification they are asking for, I am not supposed to just tender or it is not my case that I should have also got that qualification of bridge course. That is not my case. Because otherwise I am entitled, and my lord, education since is both central and state subject, my lord. And when there is a specific notification of NCTE, that too for the year 2010, so naturally, my lord, 2013 notification of the state government, that comes below to the NCTE. So my respectful submission before your lordship.
13, which one?
2013, that is at page, my lord, 27. They have the relevant portion at page 28, what they have banked upon while rejecting my prayer. They are asking for 6 months bridge course. My case is this, that I don't require such bridge course since I have my B.Ed education, I mean qualification in 1978, and that is more, my lord, powerful, Bachelor of Education. And bridge course is nothing but, my lord, to an arrangement for stopgap arrangement, my lord. And while rejecting my prayer, my lord, they have not considered that notification of 1996, where it has been clearly mentioned that I don't require, I mean, what qualification I have, I am entitled to get A category scale.
Okay.
If that be so, my lord, then the respondent is not correct. That is my case, my lord. So my respectful submission or my prayer before your lordship is this, that I am entitled to get A category scale since I have retired in 2013. So considering my entire service period, the pension may be adjusted and the area payment may be given.
You have been getting pension under category B.
Category B.
And you have taken admission for completion of the course.
Sorry, my lord.
You have taken admission for completion of DLED course.
No, 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 no.
You have done
That,
nothing.
no, no, no. Never.
Come to section 23 proviso of the Right to Education Act.
My lord, that is, I am handicapped, my lord, that is not with.
I read it for you. Qualification for appointment and terms of condition service of teachers. Yours is 2000. Any person possessing such minimum qualification as laid down by an academic authority authorized by central government by notification shall be eligible for appointment as a teacher. 2009. Now, where a state does not have adequate institutions offering courses or training in teachers' education, such and such, are not available in sufficient numbers, the central government may, if it deems fit necessary by notification, relax the minimum qualification. This is relaxation of the minimum qualification. 2009 and 2010 is the NCTE. Why this NCTE forms that particular qualification? Now is the answer. Provided that a teacher who at the commencement of this act, 2009, you didn't have the qualification, does not possess minimum qualification, 2010 minimum qualification not given, you are not having that. As laid down under subsection 1 of that section, it gives the minimum qualification as secondary plus DLED. Shall acquire such qualification within a period of 5 years.
Then, my lord, that is the, your lordship has just read out the 2009 notification. And
so that's why I asked you, did you take any admission? Did you make endeavor to complete that minimum qualification?
Then
then if the minimum qualification is not there, so far as 23 proviso clause is concerned, then how do you claim A category?
1996 notification.
1990s only?
Well, that is right now. If your lordship kindly give me next week, since your lordship takes up the matter on every Tuesday, I will provide.
Firstly is, my lord, the order passed by the DPSC, my lord, if lordship takes that order once, my lord will find, my lord, that he is relied on 1996 notification. Now, my lord, page 33, lordship. Can it takes, my lord, first, second, third, fourth paragraph, and whereas as per order of the School Education Department bearing memo dated 4/3/2013, teachers who possessed BA degree and appointed before 1/1/12 and subsequently completed 6-month bridge course from NCT recognized institution in elementary education may be allowed a category scale of pay. Next one. Whereas the teacher appointed prior to 1996 and also obtained B.Ed, BT, PGT degree diploma prior to 1796 may be allowed a category scale of pay. Whereas the said guidelines are followed in disposal of matters related a category scale of pay to primary school teachers. Under the above facts and circumstances, clear that the petitioner is not entitled to get a category benefit as per existing rules. Now, my lord, kindly takes his representation at page 31. In his representation, my lord will find, my lord, he himself says that he retired in 2013. And this representation was made in 2019. That is after 6 years. After retirement, after 6 years, my lord, he made representation. Prior thereto, from the letter, my lord, what I find is, my lord, with due respect, second paragraph. Sir, previously on 4/1/2001, 9/7/2001, then 2009 and 2011, I applied before you, treat me a category teacher, grant me said pay scale, but till date no result. This application in continuation of my earlier. So, my lord, he has attempted to make representations for making him grant the benefit of A category scale of pay, but did not qualify. That has been mentioned in the Millard, in the order itself, Millard. He possessed this degree in 1978, and in 2000, Millard, when he joined service, Millard, at that point of time, Millard, this was not taken into consideration, or he has not make any demur with regard to the fact that I have possessed this B.Ed degree, so I am entitled to get the A category scale of pay. Not a single whisper since 2000 joining until the retirement. After retirement, my lord, in 2019, he is very serious about his, my lord, things, my lord, and he filed a case prior in earlier matters, my lord. His lordship relegated the matter to the DPSC for appropriate order. Accordingly, this DPSC has passed this order. What has fallen from his lordship, my lord? She has not come within the zone of consideration because she has not possessed that B.Ed degree and other qualifications. In the notification, my lord, at page 27, my lord, she will kindly take page 27. That is the notification of 2013. In paragraph, my lord, paragraph 2, lordship. Teachers completed 1 year diploma in primary teacher training course and appointed after 31/12/2005 and subsequently covered 1 year bridge course through NCT recognized institution, provided such category of teachers may be allowed a category scale of pay from the date of joining and so and so. His lordship dealing such types of matters, my lord, on several matters, his lordship passed order showing that they are come within the zone of consideration only because of this notification 2005 and 6-month bridge course. There are instances lordship has decided. Now, my lord, kindly see, my lord, teachers who have attained 1 year or 2 year diploma in elementary education from the state recognized institutions and appointed as teacher on or before 2005 shall be treated as a trained teacher. He has not come within the purview of this also, my lord. Next, my lord, the teachers who have attained the degree, diploma, visa, DLED, special education or B.Ed special education from RCI recognized institution and subsequently covered a 6-month course in elementary education from NCT recognized institution. In this case, nothing of that sort has been happened. Now, my lord, the teachers who possess B.Ed degree and appointed before 1/1/2012 and subsequently completed 6-month bridge course from NCT recognized institution in elementary education. Lastly, the teachers appointed, this is very important, prior to 1996 and also obtained so and so prior to 1996 may be allowed. So, according to me, my lord, the order passed by the chairman is absolutely on the basis of these notifications. He has not completed the bridge course, nor the 6 months bridge course, nor, my lord, he has that DLED degree, nothing. He is well aware about the fact, my lord, that he joined in 2000, and it is not believable that he do not know that all these periphery are there, my lord, to cross these hurdles. And he made representation. It is not that he is sitting idle. He has made representations, but did nothing. Now, in 2019, my lord, for the first time, he had referred those representations, though that has not been annexed, my lord. He has said that nothing has been happened. Quite rightly, my lord, authority has not done anything.
Now, my lord, in reply, I just submit that harping on the same
Notification
point.
1996.
1990 notification, he has not come, my lord, because in this notification, my lord, you will find, my lord, it has been mentioned that he has to, my lord, last paragraph, appointed prior to 1996. He has joined in 2000, not prior thereto.
So he or she will be guided by which clause?
This, my lord, this DLED and all, because he joined in 2000 and my lord, 2005, lordship, that 6-month bridge course. If he obtained that 6-month bridge course, my lord, then the consideration part will come, my lord. Prior to since he joined in 2000 and my lord subsequently retired in 13 years of his service in between, my lord, if he completed that 6-month bridge course, then, my lord, lordship has passed orders, my lord, with regard to this, my lord. Here, my lord, the 6-month bridge course has also not been done by the petitioner, my lord. And whereas he passed in 1978.
So, my lord, a person who passed, suppose, my lord, the MBBS or MD degree in 1970, he is not entitled to practice in 2026.
No,
That is his
methodology
submission.
is incorrect.
The other thing is this, my lord,
Incorrect
your lordship kindly, since when she joined the school, my lord, in 2000, then which circular will guide her? let him say that this circular is applicable to him. NCT was not there in 2000.
Then the delay question comes, my lord.
Delay that was
Yes.
condoned by the High Court, page 29. The representation was disposed of by the authority concerned by virtue of the order passed by Justice Amrita Sinha.
Nothing, according to Millard, nothing wrong in
So in 2000, which circular will be there? Obviously 1996.
You have not completed that course.
Yes, my lord.
Which course? No. I never entered into that course. That is my admission.
You had to enter that. 23(2) provides that you shall complete that.
My lord, that is the 2009.
2009.
23 of
2009 you were in service.
Yes, ma'am.
2009 I was in service.
Then why didn't you complete? What is the reason for not completing?
Because of that 1990.
Law gave you the right that since you are not possessing the minimum qualification, you do it. And notification of NCT comes, yes, this is the minimum qualification. Upon getting opportunity, you did not exercise your liberty to complete that course.
My lord,
And
but
now you say that you provide me a category
they
of.
have not, my lord, set aside that circular of 1996.
That is.
There is no which part.
No, that is not required. The law requires that you have to complete that. Now the NCT guidelines has to be followed. If NCT requires that, then you have to complete that.
Then might dismiss my application.
Ashu. Affidavit of service. Affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record.
My lord, this is the earlier. That is the after
Taken on
changing the
record.
regime. My lord.
By the present writ petition, the petitioner seeks for setting aside of the order dated 15 January 2025 passed by Chairman, District Primary School Council, Uttar Dinajpur, rejecting the prayer of the petitioner for grant of A category scale of pay. The petitioner contains that she joined as an assistant teacher in Patida Free Primary School on 8th March 2000. Patida Free Primary School, Raiganj, North Circle on 8th March 2000. The petitioner completed her BA degree in 1978 from the University of North Bengal. The petitioner retired from service. The petitioner was subsequently transferred to Fakir Tola Free Primary School. And she retired from service on transferred on 31st March 2013. No, she retired on 31st March 13. No?
Yes, one.
In this subsequent school, when did she join?
That information is not available. It joined on 6th of March 2000.
In paragraph 3, Lordship will find that the petitioner on 8/3/2000 joined Potida Free Primary
Transfer টা কবে হয়েছে সেটা
Fakirtola Free Primary School. Transfer ওইটুকুই থাক, জয়েনিং দরকার নেই। The petitioner retired from service on 31st March 2013. The petitioner is receiving pension on and from 1st April 2013. Though the petitioner possesses B.Ed degree, but she has not been granted a category scale of pay.
But may I draw your lordship's attention for once, page 21. Page 21. That is the representation, paragraph 2. It is learned from memo number such and such dated 67 that an assistant teacher holding B.Ed degree is entitled to be treated as a category teacher. So my submission is this: since at the time of joining Malat, I was guided by this circular, so the subsequent circular
This is a
not
circular of
applicable.
DPI, Director of Public Instructions.
He is an authority.
How?
He is an authority.
After the NCT guidelines, one has to follow the NCT.
Yes.
Well, my
How give it
submission
down?
may be recorded. At the time of joining my school, those circulars were guiding my service. After NCT,
No. In terms of the order of NCT, this notification dated 4th March 2013 has been
yes,
been issued.
obviously, my lord, those are the subsequent circulars. Daily it is upgraded, but at the time of joining, my lord, those circulars were available. My submission may be recorded.
So you place that document? Place that circular?
My lord, if that is not with me, if your lordship just give me 7 days time, I would have prayed for 1 day time, but since your lordship takes pension matter on every Tuesday, so next Tuesday I will bring these 2 circulars. It is available in the headmaster's manual.
Section 19.
Milord, in the page 27, Milord, I just read, Milord, page 27, that circular of 4/3/2013, Milord, it has been mentioned, Milord, in inviting a reference of your letter vide 1926 to ES dated 9/1/2013 and without prejudice to earlier orders of this department.
Which one?
Milord, kindly takes page 27 at the top. In inviting a reference to your letter vide dated 9/1/13 and without prejudice to earlier orders of this department in this regard. So, Milord, earlier orders goes, Milord, after this, Milord, according to me, Milord. It is clear from the notification.
What is the date of that notification? 96?
96 notification date, my lord. Page 19, my lord. 31st May 1996. 31/5/1996.
Maybe. No, there is no such notification. 31st May 1990.
If your lordship just gives me 7 days time, I will try my luck because that is the submission received by the authority concerned and they have not dealt with this issue. They have not dealt with this notification. That is why I am praying for only 7 days time. So that in the next week, if there is any such, I will produce, otherwise I will leave.
কেটে দিন তো। একটা থাক, বড় হয়ে যাবে ওটা শুধু শুধু, ওটা দিলেই তো ওটা এসে যাবে, সেদিন আবার একই কথা বলতে হবে। Mr. Sanjeev Bandyopadhyay, an advocate for the petitioner, seeks accommodation to produce the copy of the notification being number 352 SC within bracket P dated 31st May 1996, issued by Joint Secretary Education Department, Government of West Bengal.
And also, my lord, the 1967, that is at page 21. I mentioned before your lordship. 1967. Both I will try.
You will mention all right.
দেখো যদি পাও।
তুমি বললাম কেন?
নেই।
Notification under memo number 306 SCP dated 7th February 1967 of this DPI is
Director of Public Instructions.
Director of Public Instruction, West Bengal. In 2001, you pressed the notification of 1996. In 2009, the letter does not have any mention of 1996. Now you are not claiming your A category on the basis of 1996 notification, which you have submitted.
1996 and also.
No. What I am on is, in 2001, you made a prayer for A category. You based your prayer on the basis of 1996 notification. Not considered. 2009, when you are pressing for your prayer, you are pressing on the basis of 1967 notification. There is no mention of 1996.
That is the hyper technical defect. Your
No,
lordship is
what is
pointing out.
not hyper technical. Nothing is hyper technical. After 8 years, you find out a notification of 1967 and giving a go by to 1996, which was your earlier prayer. If you say that 1996 you are entitled to stick to that. Or else you stick to both the notifications, which entitles you.
Both.
But in 2009, that has been given go by. You are not pressing for that 1996, what I find.
But my submission is twofold. Number one, 1967 is guiding me and 1996 is also guiding me. That is why, my lord, I pray for an
Produce that. Produce.
I will try.
Not try, produce that. Otherwise, how can I consider that?
But only 7 days, my lord. Only 7 days.
I am granting you time. Don't try. Give that, because I am not finding in this manual. Sure. After 2 weeks পরে রাখো।
Deeply obvious.
সুজিত, নামটা দিয়ে দিন।
But I beg to appear for the petitioners, my lord. So on the previous occasion, I have completed my argument, my lord. Mr. Suleiman started, my lord. Today, my lord, your turn. My lord, as per your lordship's previous direction, my lord, we have served a copy of the writ petition upon Miss Mary Datta, my lord. But she is not here.
Who is for the state?
I was directed to serve upon her, but I was told she is appearing for the state in this matter, my lord. So I have served a copy of the writ petition upon her, my lord. My lord, in all fairness to her, my lord, the service was effected yesterday only, my lord.
Nobody is appearing for the state.
My lord, Loknath Chatterjee appears made by Loknath Chatterjee.
Lordship, I beg to appear on behalf of the Madrasa Board. I was addressing your Lordship on the last.
My lord, for my learned senior addresses your lordship, my lord, I would bring you to your lordship's notice, my lord, that the writ petition which was pending in the Honorable Supreme Court, my lord.
Yes, yes.
That
This is already, yesterday it was decided.
yesterday, my lord,
And all their claims and everything goes away, your Lordship.
teachers, those
Teachers. And this matter, your Lordship knows that it is very much connected with those backdoor teachers' appointment. As I was addressing your Lordship on the last occasion, that it was an admitted fact, your Lordship, that it is an admitted position that some of the local persons were appointed as the teachers in the madrasa, your Lordship. So these teachers also approached the Honorable Supreme Court for the disbursement of their salaries and whatsoever, but that was
So these petitioners are also here.
Lordships.
No.
These petitions, তোমরা করো 350
এক minute. My lord, petitioners before your lordships are the elected members of a managing committee. They are not teachers.
And some of the teacher of this institution,
Yes.
whom the elected members of the body had recruited, your Lordship.
Not
That is the magic, your
not
Lordship.
this managing committee.
That is the magic.
Not this managing committee.
Not directly, but indirectly, somehow. Your Lordship, your Lordships, and on the last occasion, your Lordship, I was harping upon a stopgap measure or during the pendency of that matter, Sheikh Mohammed Rafiq in the Apex Court, which was decided in 2020. And during this stopgap period, a notification was issued by way of which some guidelines were enumerated, by way of which the teachers were supposed to be recruited. And I'll place reliance on Rule 4, your Lordship.
Yes.
The appointment of teachers, এটা তো rules আছে এই দেখো আমি আমার কপি দেবো the appointment of teaching and non-teaching staff, including the post of headmaster, headmistress, superintendent, shall take place after selection from the eligible candidate obtained through open advertisement as per Annexure 1 in at least 2 state level dailies, of which one will be in Bengali, in order to satisfy the provisions of the equality of opportunity and enshrined in Article 16 of the Constitution of India. So, for the appointment, certain prerequisite qualification or had to be taken by the managing committee. The first thing was it has to publish about the vacancy in the 2 dailies within the territory of West Bengal, and one was to be a Bengali newspaper. And what we have seen, your Lordships, on the earlier occasion, I have drawn your Lordship's attention towards the statement which was deposed before the committee by the TIC of the managing committee. He has specifically stated that some of the teachers were recruited in the said madrasa without compliance of the established procedures.
Those are the petitioners in the for the Apex Court.
Yes, your Lordships. Now, your Lordships, the sub and if and thereafter Rule 5, it goes a little bit further. The selection committee, the appointment shall be made by the managing committee which will frame the norms and election procedure at least 3 months before the written test and interview of the appointment in question, and the same is to be communicated to the Office of District Inspector of Schools, additional District Inspector of School concerned, and the Director of Madrasa Education, West Bengal. The Madrasa Managing Committee shall also constitute a selection committee for the purpose and initiate the same to the concerned inspector of school. So the DI is to be a very much necessary interest person. He has to inform the DI. The DI has to give an additional DI, district inspector of school, or the district inspector of school should be in the part of the selection committee. But nothing was followed over here.
At the time when these teachers were appointed by the erstwhile managing committee, you were the subsequent one. This particular notification was in vogue.
No such note.
This notification which you are.
This was in these notifications.
This is dated 3rd March 2016. Does
2016.
The irregularity pertains to the period of March 2016?
During that period only, Your Lordship. During that. One question had fallen from Your Lordship on the last occasion, that my learned friend was also harping upon the same, that during the earlier tenure, during the tenure of the managing committee, some illegal or backdoor, I'll call them at backdoor teachers were recruited. Now, what is the present managing committee? They are stating, now my learned friend was harping, I am the present managing committee, I am into the helm of the affair of the running of the institution. But I pause here for a while, Your Lordship. If I had taken charge from the earlier managing committee after my election. So it is my duty, Your Lordship, when I take over the charge, I take over everything, and that too a resolution. By virtue of a resolution, everything is jotted down over there. If there is any discrepancy, if any, it has to be jotted down in resolution that these are the things what we have found, and we carry forward the same. But no scrap of paper was brought before the Honorable Court to show on record that they had raised any dispute regarding the earlier appointment. And some of the managing committee, Your Lordship, were also a part of the earlier managing committee. ওইটা দে আমার ইয়েটা দে কবে তো
If the managing committee does not report to the district inspector of schools that what are the irregularities, what is the process that is available to the authorities to cause an inspection and find out whether there are any irregularities or not?
Now, Your Lordship, first at the outset, some of the teachers, they were recruited. To be very precise, I'm coming to the point of the recruitment of the teachers. Some of the teachers were recruited, and by virtue of this notification, the managing committee was equipped with this notification, and that was valid for that particular period of time. Now, taking that notification for granted, they recruited. The authorities could not do anything because of the matter which was pending before the Honorable Supreme Court. Thereafter, when the matter was decided, the authorities started functioning. The authorities called them for reports, and the managing committee of the various madrasas throughout the West Bengal, Your Lordship, they approached the DI for the regularization of their services, which the DI gave under sheer compulsion in some cases, because the managing committees were equipped with the judgment of the Honorable Apex Court, as your lordships can better understand the condition. Thereafter, a three-member body was constituted to look into the matter, to fish out who were the genuine teachers and who were not. And from this, all the discrepancies came forward. So everything, a can of worm was open, as your lordships can understand. Then thereafter, they preferred an application before the Honorable Supreme Court, claiming the salaries and everything, which they as if they wanted to show that all the teachers, whosoever were recruited during that period, were all genuine teachers. And on records, they had shown that we have complied with all the procedures. Now, during this turmoil period, as I may say, so no coercive measures, no strict measures could be taken because of the pendency of the apex court matter, Your Lordship. As we cannot, the authorities cannot play with fire. If anything goes wrong, then what we have to face the contempt at that particular point of time. So it is because of that the situation arose. Later on, when the issue was decided by the apex court, the authorities started writing to them. Okay. That what are the documents, what are the materials on record. And
this is of Sheikh Muhammad Rafiq. That judgment was that point of
Lordship,
time pending.
Judgment. I'm the decisions of the apex court. I have handed over to your lordships. Page 21. Page 21, your lordships. Why there was an impediment on the part of the authorities.
Yes.
Paragraph number 14. The head of the institutions and or the secretary of the managing committee shall be personally, jointly liable if any appointment is made on the basis of panel prepared by the school authority by way of illegal and irregular procedure, or panel prepared against any unauthorized vacancy not duly approved by the competent authority. Government shall not bear any financial liability of such illegal or irregular appointment, and the district's inspector of school concerned shall not be bound to accord approval or give any recognition to such illegal appointment. So it has been specifically mentioned and decided by the apex court that no such illegality shall sustain, and everything goes. And at the commencement, at the end of the paragraphs, your lordship, the court was of paragraph 44. Since the interim orders has been vacated, the vacant sanctioned post may now be filled up as per the recommendation of the commission. So there is no space left for these teachers as well. And moreover, the writ petition being thoroughly misconceived, we would have been justified in imposing cost. The court held the view that we were justified in imposing cost. However, since we are not directing release of areas of salaries and allowances, and also taking a lenient view, we refrain from burdening the petitioner with cost. So it was such a view taken by the apex court. So the gravity of the matter was such, because it was directly, the government exchequer was directly involved for the recruitment of these fake teachers. Now, what is the sub and substance of this writ application, your lordship? The West Bengal Board of Madrasa Education, the District Inspector of Schools, these are the authorities established by law for the functioning of the madrasas within the territory of West Bengal. Now, a madrasa, the functioning of the madrasa, instant madrasa, is looked after by a managing committee. Now, if the higher authorities, the district inspector of school, or say about the West Bengal Board of Madrasa Education or the Directorate of Madrasa Education, calls for any document, I put a question to myself, where is the high-handedness? And when the writ petition itself goes on to show it has the erstwhile teacher in charge has deposed before the three bench committee that those resolution, to be very precise, those resolution, he was not equipped with those resolution by virtue of which these teachers were appointed. And if I call for those documents include a lot of documents which are related to the functioning of the madrasa, your lordship. It can be a piece of paper and it can be a bunch of paper. So my learned friend was precisely harping upon only the paragraph 1, form A only. But in my notification, in my address to the managing committee, we have called for form A and the other documents. So other documents include everything. Moreover, your lordship, kindly consider that when he has also stated that he had went to the being this TIC or the managing committee of the secretary, went to the office of the DI containing a bag full of document which was left over there or misplaced or whatsoever. Did he take the pain to lodge an FIR? Because these are very important documents. I place a question, did he lodge an FIR? No such question has been raised. No such thing has been placed before your lordship that an FIR was lodged, because these are very important documents for the functioning of a madrasa, your lordship. And he's stating simply that a bag full of document, he had taken it to the office of the DI and it was left over there. Rightly, wrongly, whatsoever, it is his contention, but the contention has to have legs to stand on. No, if there would have been an FIR, then we could have understood, okay, he had taken a bag full of document. Moreover, simply, I had appointed an administrator, then everything or a can of worms open, he comes in and he files a writ application. Why? Because I asked him to provide me with certain documents. The language what has been used, that the authorities have raided illegally the district inspector of schools cannot visit the madrasa premises. The secretary or any of the officials of the West Bengal Board of Madrasa Education cannot visit any madrasa authority, any madrasa. Where is the high-handedness? Rather, the high-handedness is when I have been called for the document and I don't provide this with the same. No resolution book copy. Those resolution book copies has been missing, by virtue of which the teachers were illegally recruited. Moreover, I put a question to myself, whenever some TIC is called to the office of the DI, the TIC is replaced. There is a what urgency is that one? The TIC puts in his paper stating health ground. The TIC puts in 3 times. The TIC has been changed. Why? All of a sudden, because the documents were called for. Thus, there is something fishy about the managing committee. Thrice the teacher in charge has been changed, your lordship. It is on record, your lordship, and that too in his writ petition. Paragraph number 7. Paragraph number 8, 9. It specifically goes on showing that thrice the teacher in charge has been changed.
8, 9 of?
8, 9 of the writ petition, your lordship. Page 6. Your lordship may find it from page 4, paragraph 4 also. Page 6 and page 7.
Yes.
Now, your lordship, I'll place before your lordship. Dag nahi to dag dewa nahi to. Dag dewa thakle dite parbo na. Sahib. Oh, sahib. Sorry.
Yes.
Lordship, I'm referring to page 83. That is Rule 8. power of the board to approve and supersede the committee. When will the board supersede the committee? On what circumstances? Just I gush shot the matter, Your Lordship. I'm not encroaching upon Your Lordship's valuable time, Your Lordship. Now, I have showed on record that there was a deliberate thing from the managing committee to not to comply with the authorities, not to comply with them. Thrice the teacher in charge has been changed. It is an admitted position that some of the teachers were recruited. I call them as backdoor recruitment. Now we are equipped with the judgment of the Supreme Court as well, where all the teachers goes. I have placed before Your Lordship the notification. The notification has to be followed, but nothing was followed. And I have placed before Your Lordship the statement of the erstwhile teacher in charge, which he specifically states that no teachers were recruited compliant in compliance to the notification. Moreover, he has specifically stated that those resolution were missing in the school premises or madrasa premises, by virtue of which these teachers were recruited.
What is the date of recruitment of the teachers?
It is the managing committee may state, Your Lordship, because we are not equipped with the same. The managing committee will be in a position to state that. And moreover, I'm just placing before Your Lordship page 83, rule 8, power of the board to approve and supersede the committee.
This is of which rule this is?
It is rule 8, Constitution of Managing Committee rules 2002.
Rule for management of recognized non-government madrasa aided and unaided 2002.
Page 78, Your Lordship, may find it. Rules for management of recognized non-government madrasa aided and unaided.
The epidemic in opposition.
Okay. ঠিক আছে স্যাটিসফ্যাকশনের জন্য করতে দাও না
Yes.
Yeah, Lordship. May I? So what are the instances on which the board can supersede the power of the managing committee? Just for our understanding, Your Lordship, may I just place him before Your Lordship. The board will supersede the managing committee. So the board cannot do it directly by its wings and organs. The board takes over the functioning of the managing committee. And it is, Your Lordship, a stopgap measure. It is not a permanent position. So that the managing committee, if it was not functioning as per the rules which has been laid down or the guidelines which has been laid down, so that managing to stop functioning, the board takes the affairs of the managing committee by an appointment of a DDO, sometime directly the administrator. So this is the constitution of the committee shall be subject to the approval of the board. Now, if there is any election, as Your Lordship knows, if there is an election, the same has to be forwarded to the board, and the board accords sanction to that managing committee for a period of 3 years. Now, the board shall have the power to supersede a committee if it is satisfied from the report of district inspector of school. In this case, Your Lordship, we are equipped with the report of the district inspector of schools or schools director or otherwise that the committee has not been functioning properly. And so it has been conjoined, and if it is if the committee has not been functioning properly, and if the committee fails to comply with the direction of the board or director or the government of West Bengal, as the case may be, so this is purely a non-compliance. This case is a purely non-compliance of the authorities, the district inspector of school, the West Bengal Board of Madrasa Education, because we have called them for a meeting, for a hearing. They never bothered to come down to the office of the board as well. ঠিক আছে আমাদের অ্যাফিডেভিটটা
Yes.
আমার অ্যাফিডেভিটটা তুলে দেখা। So I'll place before your lordship the affidavit in opposition on behalf of the respondent number 2, 3, and 4.
Any other provisions you want to indicate in Rule 8?
That is the only crux of the matter, your lordship. That will suffice. A plain and simple reading, your lordship.
This affidavit in opposition of?
My affidavit in opposition, your lordship.
Yes.
Your lordship, page 4, paragraph number 7.
Yes.
4th line, your lordship, I'm reading. I'm not bothering your lordship with reading all the everything. By successive communication dated 23/5/2025 and 27/5/2025, called upon the concerned madrasa authority to produce relevant documents. As I pause here for a while, your lordship, my learned friend was harping upon that the madrasa authorities or the district inspector of schools had only called for Form 1, which is, your lordship, which I can ascertain from here. Upon the madrasa authority to produce relevant documents and documents for necessary verification. However, no response was received from the madrasa authority in this regard. Now, I'm placing the photocopies of the communication date is 23/5/2025 and 27/5/2025 and 29/5/2025. These are marked as Annexure R2, which is on record before your lordships.
Yes.
Now, paragraph 8, the opportunities of hearing granted, however, in every occasion, cooperation from the managing committee of the madrasa not received. The district inspector of school Malda submitted report to the West Bengal Board of Madrasa on dated 30th May 2025 and 17th June 2025, pointing out the grave irregularities at the Batna JMO Senior Madrasa. Now, what are the grave irregularities, your lordship? The recruitment of the teachers. Now, if I take over the charges from the erstwhile managing committee, I ought to have reported it to the district inspector of school at that particular point of time, or to the West Bengal Board of Madrasa Education that there was such an irregularities at that point of time as we had taken over the charge. So it will be carried forward definitely, your lordship. If you cannot discharge this duty, how can you manage the students in the madrasa, your lordship? This is a very vital duty. Whereas the interest of the students should be paramount. But this goes otherwise, your lordship. And the magic follows, your lordship. In every subsequent event, the teacher in charge is changed. I put a question, it's magic, your lordship, because maybe he's not complying with the terms what was imposed by the managing committee. We can ascertain the fact. So these are my innocuous submission before your lordship, and I'm praying for the with heavy cost, your lordship, because these kind of frivolous writ petition travels to the court and encroaching upon your lordship's valuable time, and that too for irregular stuffs. At least for a valid thing, something we have ought not done, we should have ought done it, then it would have been sufficed, your lordship. But these kind of things should be restrained. and with heavy dismissed with heavy cost, your lordship.
What is the statement?
That I saw Miss Doctor here. They were there. Right now, yes, she was there, madam. Madam, meanwhile, if your lordship permits me, madam, can I just reply to what you said?
Let her complete. Who is it? They have filed their opposition, no?
Yes, yes. Yes. She was there actually. I don't know why she left. She came and then she left.
দেখো ভাই একটু দেখে নাও ভাই কোর্টে মামলা চলছে কোর্টকে বলে যাও কিছু করো এ তো মানে আজও মুশকিল হয় রে কোর্ট হাইকোর্ট একটা প্র্যাকটিস করতে গেলে একটা জিনিস করতে হয় ভাই
Administrator has been appointed in this.
Lordship. It is because of that they are before your lordships.
And a FIR has been lodged.
Lordship?
Any criminal FIR has been lodged?
No, no such FIR because yesterday only this order has come, your lordship. So subsequently things will be done and the board is not functional as well. The board is running with only with the secretary. And just to praise your lordship, the administrator was appointed long time back. So it is
You have
on the
filed that?
verge of.
You have filed the letter of appointment of the administrator?
Yes,
हाँ,
madam.
हाँ,
No,
आके
that administrator was appointed subsequent to the filing of the writ petition, my lord. The copy that is annexed to the writ petition is the appointment of a DDO, withdrawal and disbursal officer.
এই তো তোমার তো দেওয়া আছে গো দেখো না বলছো তো administrative annexure P12
Proposal, that is a proposal. That's a proposal.
আমার কাছে আছে ওটা ডিডিও না
10 days মাথায় ডেট দিন Mr. Nadim Sulaiman, learned advocate representing West Bengal Board of Madrasa Education, concludes his argument. None appears on behalf of the state despite, you have given notice?
Yes, yes.
Despite service of notice. For ends of justice, the matter is adjourned. Is this matter on 10 দিনের মাথায় ডেট দাও ওটা 3টের সময় 3টে 3:30 How long you will take to reply?
Reply will take, my lord, hardly 10 minutes.
আল্লাহ ছোট্ট করে টাইম দিবে
3:30 on 23rd July.
Okay, so great.
Great.
It possibly intimate, give a notice, give a notice to the learned advocate for the state intimating the next date of hearing. এটা রাখো ওর সাথে next. Next. দিয়ে এই জাজমেন্টটা ওটার ভেতরে থাকবে Then appears on behalf of the petitioner. None appears on behalf of the petitioner, nor any accommodation has been sought for. For ends of justice, the matter is adjourned. It's a matter after 3 weeks. 3 সপ্তাহ পর state is represented.
I'm for the statement.
Same order. Same order, same order.
I'm for the statement.
Same order. 27. Same order. Next. Next. এবার not to করে দাও ঠিক আছে 596
My lord, I'm paying for a short passover. My senior is appearing on behalf of. My lord, I am appearing on behalf of the local library authorities, my lord. There is a direction to file affidavit, my lord. Affidavit is ready, my lord. I want to file this affidavit, my lord. Not today.
596
Date number. So here in Bhopal.
you are appearing for
Local library authorities, my lord. Respondent number 3, 4, 5, 6, 7, 8. My lord, the direction for filing affidavit, my lord. Affidavit is ready.
report
Affidavit, my lord. Report in the form of affidavit. Dada. Dada.
report in the form of affidavit
I have served other side, my lord.
filed by Devnath Babu filed by respondent number
That's it.
4 filed on behalf of respondent number 3
4, 5,
5,
6,
3
7,
to 8 is taken on a record taken on record copy
I have served other side.
copy served where is your exception
They served me.
exception served
Yes, I have served.
where is it
My lord, my senior is engaged in another course, so I'm paying for a short passover. Give it next date, my lord.
accommodation is learned advocate for the petitioner seeks extension of time to file exception. Let such exception be filed within a period of 2 weeks. List this matter after 2 weeks. Under the same 2 সপ্তাহ পরে
My lord, in this matter, my lord, there are several connected matters with this. My lord, kindly have a look at this order, my lord, passed by the coordinate bench. Thereafter, my lord, I am possible.
এটা দিয়েছে আমি কাজ কি দিলাম
ordinary advocates appear behind instant petition we heard logically yes
Mr. Bandyopadhyay was engaged in this matter, my lord, for amicus curiae, my lord. Is engaged, my lord. He is on legs in court number 35, my lord.
whatever the affidavits have been filed
My lord, in this matter only, no,
Although there was a direction.
there was a direction, but no affidavits have been filed. By lord, on the last occasion, there was an understanding by the coordinate bench that a point of law is involved, nothing on facts.
Only.
My lord, an interpretation of a circular which says, my lord, Labor Department circular says that if any vacancy in a recruitment is not filled up in a reserve category, that is, my lord, under ex-servicemen or, my lord, in exempted category. Suppose, my lord, there are exempted OBC category, OBC A. There are 10 vacancies. 5 have been filled up.
those remaining 5 vacancies are to be converted in the corresponding OBCA. This is the, my lord, circular. The wording in the circular is because of non-availability of suitable candidates. My case is I am an OBC candidate. Because of non-availability of exempted OBCA candidate, that should be converted. My lord, what their client has done, my lord, they had, my lord, converted some and not converted some, taking the plea, my lord, that after the merit list has been prepared, so it cannot be converted. My point was, unless and until the merit list is prepared, nobody can ascertain who is not available, what vacancy is not available. My lord, on this point, my lord, Mr. Bandyopadhyay was appointed as amicus curiae, and since these two issues matters were lead matters, my lord, they were to be required to be heard. So, my lord, may I suggest one thing subject to your lordship's convenience, since all these matters, my lord, there is to be heard analogously. My lord, your lordship can direct a date to be along
Fix another all the matters, my lord, kindly hear them, my lord. I will.
It will not take much time. Overall, my lord, it will not take more than 1 hour. My lord, these are recruitment of local librarians.
The authorities.
My lord, they have been, my lord, this is the 3rd round of litigation. My lord, any day fixed by your lordship, my lord, it will be over. Very short point, my lord.
So this will be heard along with all these repetitions.
All these matters, my lord. Only all these matter will be heard, my lord. Same
After this order, the determination has been changed.
Yes.
Yes. Court number 20.
Yes, my lord.
তাহলে এটাকে ব্রিফ করে দিও।
কি দুটো ম্যাটার আছে রোড
এই অর্ডারে
আর একটা
এই রিট পিটিশনস গুলো আছে and the writ petition WPA 2017 of 2026, the second page of that order.
Yes. My lord, all are lordship's determination.
ওকে, তাহলে এগুলোকে সব উইথ করে দাও, অ্যানালোগাস বলেছে, ঠিক আছে। এখানে পাবে ফার্স্ট পেজে কিছু WPA আর দুটো হচ্ছে পরের পেজে আছে, এগুলোকে উইথ করবে। আর এটাকে Mr. Sudipto Dasgupta, learned advocate for the petitioner, submits that similar issue has been directed to be heard analogously with other writ petitions. Vide order dated 13th February 2026, passed in WPA 11375 of 2025. It seeks that the matter be listed along with the other writ petitions which has been directed by the coordinating bench of this court for analogous hearing, since the issues are same. In view of such submissions, list this matter on ওটা কবে আসবে আমাদের লাইব্রেরি রেকর্ডস গুলো? তাহলে 3 সপ্তাহ পরে একটা ডেট দিয়ে দিন এটা, আর ওটা এলো ওটা অ্যানালগাসলি অ্যাপিয়ার।
My lord, in this matter,
After 3 weeks, this matter will appear. In the meantime, they will get the records from the department and list it. Those matters will be analogous since there is an order. I'm not passing any order regarding analogous of hearing. On that day, it will be listed.
My lord, only one thing subject to your lordship's and kindly fix a date. After a long persuasion, my lord, kindly see, it was hard intensively. From March, I could not even get the matter listed.
Which one?
Fix a time, it will not take much.
Which time?
These matters, my lord.
my lord,
My lord,
in these two matters,
any time, my lord, any day, any time.
4 PM library matters will be taken up on.
My lord, half an hour, my lord, only difficulty is half an hour, it will again split over, my lord. 1 hour, it will be over for everybody, my lord.
Okay. এটা কি লাইব্রেরিতে একটা হিয়ারিং এর ডেট নাও, হিয়ারিং এ নিয়ে এসো। আচ্ছা 2 weeks এর মধ্যে কি ওটা আনা যাবে? What I suggest is, let the records be received by this court, let it be listed after 3 weeks.
Yes,
on that day, you place this submissions before this court. I will fix a date under the heading hearing, giving a time.
my lord.
Let the records be received at the first instance.
The next matter also same. In these two matter, my lord, I am appearing on behalf of the local library authorities, my lord.
Same, my lord.
Same, my lord. Same, my lord.
In this order also, that number is.
Achha.
Both are same.
Correct.
Both are same.
590.
598.
598 and 599.
597 and 598.
Oh, 598.
Yeah. Yes,
Same?
my lord. Same.
After 3 weeks.
No, it will retain its position.
Whatever be the position you submit so that I can place it under the heading hearing, giving a time and date.
No, my lord. Only thing on after 3 weeks under the at 4 p.m. If it is
Yes.
down, my lord, then
It will not go down. It উপর দিকে রেখো.
deeply of.
I'm deeply obliged.
And appears on behalf of the petitioner.
My lord, 599 also same and identical issue, conversion library service. It will go to the same branch, my lord.
তাহলে এটা কেউ অ্যাপিয়ার করছে না ওই দিনই রাখুন 3 weeks পরেই লিস্ট করে দিন আচ্ছা এই নাম্বারস গুলো নিয়ে না কনসিকিউটিভলি
branch,
করুন ওকে
It will go to the same branch, my lord.
on after 3 weeks this will appear
I am appearing on behalf of the local library authorities.
okay no I'm not passing any order after 3 weeks this will be listed
My lord, earlier 2 matters order was passed, my lord. My lord.
no, only 97 I have passed order 98
97 and 98,
98,
my lord.
yes.
My lord. 519 also go to the same branch. I am deeply obliged.
600 দেখি নেই not today করো next week আসবে
601 602 603 604 605
5, my lord, I am appearing on behalf of the local library authorities, my lord. There is a direction to the district library officer to consider the representation. Representation was considered and there his prayer was rejected, my lord. His prayer kindly, I think, my lord, the repetition is infructuous because his prayer is to join his service, my lord. He is already retired from service. My lord, kindly have a look to the order, my lord, earlier repetition, my lord. It is at, my lord, page number 37, my lord. It is second time of litigation. And my lord, next page is page number 38. This is the reasoned order, my lord. Unauthorized leave 5 years and 5 months.
none appears on behalf of the petitioner nor in accommodation is sought for district library officer respond number
5, my lord.
5 is represented for ends of justice the matter is adjourned next week রাখুন
Next week, my lord.
yes
I am deeply obliged, my lord. My lord, do not fix it 21st July, my lord. There is some problem, my lord, in coming.
then 28th July
My lord, I am deeply 28th.
Six zero six 607 608 609 610 611 612
Okay. 612, my lord, I am appearing on behalf of the local library authorities, my lord. District library officer, my lord, respondent number 3. We made a representation before the authority, my lord. It was not considered.
joining
Not, my lord.
then
He is a casual employee.
and what is the prayer
Lord, prayer accord approval of appointment of the petitioner as a junior library assistant. It is beyond the service rules, my lord. Made a representation. It was not considered,
same order করো 28th এটা view
my lord.
28th This will come up.
20. কাগজের তো নামগুলো দাদা একটা কাগজ দিন তো। অর্ডার কত 5 দিচ্ছি।
Next.
613, 614, 615, 616, 617.
617, yes.
Affidavit of service is there. Here, postgraduate scale of pay of a librarian having master degree in library science itself. The petitioner obtained the postgraduate degree. If your lordship kindly take at page 16.
When did he join?
He joined in the year 2011. If your lordship kindly take my joining letter itself.
Or 16 pair.
No, page 22 is the first joining. Page 22 P3. Appointment letter. Then joining letter 1st July 2011.
Appointment letter 11, yes. June.
Page
1st July
2011.
2011. Okay.
Now thereafter he has been transferred to in another school by a virtue of a general transfer. So my date of joining, my lord, kindly take 1st July 11. Now I am entitled.
And you completed your masters prior to joining.
Prior to joining. Therefore, I am entitled from the date of joining. In terms of the ROPA 98 corresponding 2009, how I am entitled? If your lordship kindly take, my pay scale has been fixed, page 36. 36. My lord, kindly take in terms of ROPAs that grade pay 3900. I am being paid. My lord, got it in respect of grade pay ROPA 2009. My case ROPA 9 will be applicable. Column number 1, 2, 3, 4, 5, 6 grade pay.
Yes.
3900 is being paid to me, but I am entitled grade pay 4100.
Where is that?
Yes, I am as per law. I am giving the law then. Now, if your lordship take this ROPA 2009 itself.
Postgraduate scale of pay.
Postgraduate scale of pay by master degree holder. If your lordship kindly take last but one page. Column number 50, 13 and 14. My lord, got it. Librarian master degree holder with recognized diploma in library science. That was the scale 4650. 10,175 is the ROPA 98. That will be corresponding next page. 7100 37600 4100 get. My lord, got it. Now I am being
paid. He is a graduate.
I am being paid column number 14 graduate. That grade pay 3099. Just page.
You will be guided by 13.
I'll be guided by 13.
Okay. 7110 3760.
And if your lordship takes ROPA 98, it says I'm giving the ROPA 98 itself. It is corresponding, that is the judgment of the Honorable Division Bench also held when a guideline has been framed. If your lordship kindly take that 12.3, well, I'm marking for your lordship just one. That 12.3 part. This is the ROPA 98. That will be followed corresponding 2009. If your lordship kindly take page, paragraph 12.3.
Secondary school. It's a secondary school.
Yes, this is secondary school.
Or will improve the economy were appointed higher qualification subjects of
all teachers, including physical education teacher and librarians
appropriate to the economy
of a secondary school who have been improved or will improve their qualification or who were appointed. This is my case fitting. Who were appointed with the higher qualification in the subject or improvement related to teaching appointment shall get the higher scale. And if your lordship kindly take this ROPA is fitting at column number, my lord would go 13, page 13. of that ROPA.
This one?
Yeah, that one. Just now I am reading that fitment of how it is to be. My lord, got it?
Yes.
Page 13.
Yes.
Now column number 13 read librarian, master degree holder with recognition diploma. I was with the degree. Now fitment for just column number 4, 6450 10,170.
4650.
4650. Yes. That will be my fitment in ROPA 98. And that fitment just now I have page in ROPA 9. That fitment will be column number 13. 4650 in ROPA 98. First box.
Yes.
10,175. Just I have read column number 13 of ROPA 98. And that fitment 7100 37600 grade pay 4100 I am entitled. And they are giving 3900 at page 36.
So your pay band will be?
Will be
7100
my lord.
37600.
Grade pay.
Because we have joined after 11.
After
so,
11.
So 2009
9 will be applicable.
Yes.
Then column number 13 of 2000 ROPA 9 applicable. But I have read from this bench itself because I was not aware of this. But one of the honorable court, Justice Madhav Prasad's bench, when I argued, division bench, but his lordship guided me, kindly come to that fitment itself. But I have bought this judgment also. But I am so candid too. And if your lordship and
who
justice
are the answering respondents?
State is the respondent. I served. My lord, this is the judgment of the Justice Prasad. And in that case also it was held that I am entitled. And guiding factor has been given, my lord, Justice Sen. Kindly take.
In which paragraph you just indicate?
Yes, I'm indicating the paragraph itself. My lord, the paragraph. Yes. Paragraph 14 onwards. It was argued by the state, it states the appeal that it is governed by Control of Expenditure Act. Their lordship held no, it is not guided by the Control of Expenditure Act, but ROPA Rule 2009 corresponding to 1998. Because in this case, petitioner appointed prior to ROPA 2009. Paragraph 14, kindly take. From 2007, he is entitled to. ইনস্ট্রাকশনের দরকার নেই, এটা কিচ্ছু দরকার নেই, রূপা রুল বলছে তোমাকে। And thereafter, kindly come to paragraph 8. 8. I took your lordship paragraph 13, 14 first, then kindly come to interpretation has been given. Paragraph 8. Taking cue of column number, serial number 30. 8 and 9 paragraph, it is there. দিচ্ছি। একটা judgment মিলে নাকি না? ঠিক আছে।
Yes.
And guideline has been framed by the order passed by Justice Sen's Division Bench. I have just handed over, kindly take. It is mat number 608.
Yes.
Paragraph 5 onwards, kindly. At a glance, kindly see. Although repetition was pending, it was referred to the Honorable Division Bench by the state against that impugned order. But guideline has been framed, their Control of Expenditure Act is not applicable, and ROPA 2009 is applicable in this case because he has also improved qualification in paragraph 5. Can you take note of?
Completed. Page 3 is missing.
Hmm?
Page 3 is missing.
Oh, can you take this? I'm so tender apology to them. Oh, page 5, yes. I'm tendering apology. I could not take it up.
Case of repeating is different and there are teachers whose cases.
So clear, my lord, it is not ambiguous that, and I have made my prayer. In the prayer also, I have categorically mentioned, kindly take care of page 44. Page 43 and 44. Before the authorities, my lord, I have made categorical distinction that I am entitled grade pay 4100. This is column number 13 of ROPA 98.
43.
43, yes. Well, I've quoted that portion itself. And page 44, I am entitled grade pay 4100. In the pay band 37,600. Just rule has been quoted, my lord. Just copy paste for the better understanding. So not kindly direct the district inspector to grant me that grade pay 410.
Yes.
Representation has been filed, madam, that is required to consider, madam, in accordance with law.
Again, they will reject in any way. Supreme Court says if I am entitled to give them a benefit then and there in the judgment of the Honorable Supreme Court. Representation consideration proceedings nowadays is not the for pending litigations coming, and if your lordship grants for consideration, they will reject. Although I am entitled to in terms of that, and that division bench also quoted this.
He's
The judgment of the
entitled to, he
division
has
bench
done
is
his
there.
masters in library.
Yes.
So as per your own guidelines and the ROPA that has been issued in
Judgment of the
2009,
division
he's
bench
entitled
states
to that.
appeal. So kindly direct the DI to grant payment of 4100.
Yes. Affidavit of service filed on behalf of the petitioner is taken on record.
বাবু একদম ডিভিশন বেঞ্চ আছে তোমার রুল বলছে দেখো রুল
By the present writ petition, the petitioner seeks direction upon the respondent authorities
ডিপ্লোমা আমি এটাতে যখন পাচ্ছিলাম
to grant higher scale of pay in terms of ROPA 1998 at the scale of rupees 4650-10175 and revised refixation as per ROPA 2009 on and from date of his appointment.
In the grade pay manot kindly mention it.
In the grade pay of, you have not stated in the prayer.
Yes, not prayer, but in the body as well as
the grade pay of 4100.
My lord, kindly take note of
pay band
3700
7100-37600.
My lord,
with grade pay of rupees 4100.
I'm so obliged.
The petitioner contains that he joined as a librarian in Tolit Gaureshwar High School. On which date you joined? On
1st July of 2011. 1st July of 2011.
At the time of joining, the petitioner had postgraduate qualification in Masters of Library Science subject.
Page 16. Join degree. Master degree and information examination from Netaji Subhas Open University. Page 16. Document.
The petitioner this 3900, this is under which ROPA?
This is ROPA 2009 having the only graduate degree. Column number 14 kindly
The petitioner is drawing salary under the grade pay, under the pay band, grade pay rupees 3900, which is applicable for the graduate in library science.
Obliged.
Since the petitioner joined with the masters in library science, he is entitled to grade pay of 4100 as per ROPA 2009.
Obliged.
The petitioner, on which date you made a representation? 9th April 2026, the petitioner made a representation before the April 2026, the petitioner made a representation before the concerned authority seeking for redressal of his grievance. However, no steps have been taken, hence this writ petition. Mr. Vishwarup বিশ্বাস, learned advocate for the petitioner, affidavit submits that the law is well settled that a candidate who joins with master's degree in library science is entitled to grade pay of 4100, which will be evident from the memorandum number 46-AC within bracket B/5B-1/2009 dated 27 February 2009. In support of his contention, therefore, the petitioner is entitled to the pay band of rupees 71003760 and grade pay of rupees 4100, which is applicable to librarians with master degree holders. This is with recognized diploma in library science?
Yes, this is recognized. This is the subject. It is written in that first.
So that subject is diploma in. With recognized diploma in library science. To buttress his contention, he relies on the decision of Honorable Division Bench passed in State of West Bengal and others versus Arup Ratan Das and others, Re FMA 1162 of 2025 as number 2, State of West Bengal versus Sagorika Bhattacharjee, MAT 608 of 2023. He seeks for appropriate orders. Learned advocate for the state leaves the matter to the discretion of the court. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the petitioner is entitled to higher scale of pay in connection with his, in respect of his higher qualification or not. Admittedly, the petitioner has completed Masters in Library Science, page 16.
Page 16. In the year 2007. December 2007.
Hmm.
Page 16.
Master of Library and Information Science in the year 2007.
Top it is mentioned. In the top it is mentioned.
The petitioner joined the service in 1st July 2011. 2011. My only query is that the qualification which has been given in ROPA
Yes.
is somewhat different from the qualification.
It is mismatch. It is mismatch. They mention in the yes, can you take? I have to also check it up at page 24. Honors belief they have mentioned.
Oh.
And that mistake has been made by the DI and IOSMS portal. It has been mentioned at page IOSMS at page 36. 36 and 37. This is the portal is being used by the DI.
Which is showing believe.
Yes, 33900.
Okay.
That is why I am being deprived of it. Some
So these are same. The qualifications are same.
yes. Even kind of payment is the same.
No. This qualification in page serial 13 says librarian master's degree holder with recognized diploma in library science.
Correct. That is the same. And my if you kindly take ROPA 2009 column, page 21. Page 21, column number 13 and 14. Same pay band.
Page
21 of the ROPA 46.
Yes.
Column number 13 kindly take pay band 7100376600. And in case of column number 14 also pay band same. Only grade pay difference for higher.
No, the qualifications are same.
Yes, qualifications are the same.
Masters in information and library is same as
Master degree.
Completed his masters. Wait, hello. 1st July 2011. There cannot be any quarrel that a candidate having masters in library science is entitled to a higher scale of pay of rupees under the grade pay of rupees 4100. In view of the above, this court finds substance in submission of Mr. Biswas, learned advocate for the petitioner, relying on Arup Ratan Das Supra and Sagarika Bhattacharya Supra. Accordingly, the who is to grant?
Respond number 3.
Respond number 3. In the aforesaid conspectus,
District Inspector of School AC.
District Inspector of Schools AC.
Yes. Purva Bardhaman.
Purva Bardhaman is directed to grant the petitioner the benefit of higher scale of pay on account of his master's qualification in the subject relevant to his appointment and to refix his pay of scale, including payment of arrears within a period of 8 weeks from date of communication of this order. They will grant you the benefit of higher scale and make a refixation of that, and also calculate the arrears and do the needful.
Kindly.
Consequently, this prison being such and such stands disposed of, learned advocate is directed to communicate.
And arrear payment should be made within certain period.
Within a period of 8 weeks from date of communication of this order. All the exercise.
All the exercise.
Refixation and all, and the arrears.
I have faced some difficulties. The authorities did not do this. Again, I have to come before this honorable court for refixation and arrear, and that to interest. Justice Sinha's court, just I have filed a contempt itself. The authorities are reluctant to do this. That is why I have made. I'm so grateful to you.
Thank you.
I'm so grateful.
Sure.
But keep this with you, Lord.
Okay.
But I have also learned something from the court.
Thank you.
Yes, and this judgment is reported one.
Okay.
Just in this bench, of
Okay.
Arup Ratan Das, 2026, volume 2, CHN. I am giving the page number itself.
Give the citation
Just
numbers
today
to.
book has published.
Oh,
I am
একটু
giving
দেখুন ওটা
citation.
দিয়ে দেবো দিয়ে দেবেন
That's not me.
Okay.
Grateful to you.
Thank you.
Obliged.